chance for the respondent number 1 in this matter. Senior Advocate Pitambara was leading in this case not well, my lord. He has throat infection and fever. I have taken counsel for of Senior Advocate Popular Ratho for the appellant. Subject to your lordship's consideration, he was suggesting for a date in second week of September.
Item number 4. At the request of Mr. S.S. Party Level Counsel, appearing for the respondent, let the matter be listed on 4th of October 2023.
Page number 2, item number 7 to 14. Page number 3, item 15 to 20.
I will pardon, my lord. Item number 11, your lordship. A pay for 1 week time may be given, your lordship.
For what purpose?
My senior Mr. Mitra is not present, your lordship, out of station.
You are appealing for the petitioner.
Yes, your lordship.
Let the matter be listed on 22nd. No, it's Friday. 27th of September. Right. 2023 at the request. You are there on record?
Yes, your lordship.
You are Mr. Pranav Ranjan. What is your good name?
Rohit Mahato, your lordship. R. Mahato is there.
At the request of Mr. R. Mahato. Counsel, you are for the
Petitioner.
Yeah. Appealing to the petitioner. Have you informed the counsel of the opposite party?
Yes, my senior has informed, your lordship.
No, it isn't stated for us. The counsel for the opposite party. State counsel. Has been informed. Next.
Pardon to mention, your lordship, item number 1 may be adjourned to some other date because conducting counsel is not well. 1 week time.
Item number 1, you have to wait for regular call.
Page 3, item 15 to 22. Page 4, item 23 to 28. Page 5, item 29 to 35. Page 6, item 36. Page 7, item 37 to 40. Page 8, item 41 to 45.
Well, item number 52 kindly taken up 2 weeks after
41.
32. As the Mr. Pishpatna, he's the arguing counsel and he's suffering from dengue, my lord.
You are there on record?
Yes, my lord.
Yes,
C.K. Agrawal.
At the request of Mr. C.K. Agrawal and counsel appealing to the appellant, let the matter be listed. Let the matter be listed on October 9th of October. 9th of October 2023. Have you informed Mr. Dhanishya Mohanty?
Lordship, we don't have any contact with Mr. Mahanti. We are trying to communicate him.
You have to inform counsel
ma'am.
for the opposite party.
Page 9, item 46 to 49. Page 10, item 50. Page 11, item 51 to 53.
Your lordship, item 53, your lordship, it's an election matter, your lordship. There's a stay in behest of us. Your lordship may kindly fix a date for this matter, your lordship. The matter is ready for hearing.
This matter was not listed yesterday.
No, your lordship.
Why this matter said displayed space order was not listed? Today. So matter is there, we'll take up the matter today.
Your lordship, today, Mr.
Sorry, both cannot go together. You are asking for the urging list.
Pardon, I go down, your lordship.
So we'll take up the matter today.
Obligation.
Come prepared.
Yes, your lordship.
Yes.
Page 12, item 54 to 59.
Item 54.
The applicant is a retired older lady, my lord. She is not.
Be there at 12. We'll take up the matter at 12.
Oh, right.
Inform the council, Mr. Kuntia. This matter will take up at 12 because retired employee regarding.
Item 59, my lord. I will file objection to the limitation of petition. One try may please granted you. I am for the respond number 1.
When the matter will be called out, we pass the order. This is not a matter to be mentioned. All right, item 59, just mark it, huh? I call it up.
Page 13, item 60 to 64.
My lord, item 60. My lord, item 60 pay for 2 weeks after, my lord, on behalf of Mr. Siddheshwar Mahanti. My lord.
Why?
My lord, he is suffering from fever. My lord.
And you have not also.
The public copy is also not take care.
Mr. Who is appealing to the appellant in this matter?
Yes, my lord, item 60.
So could be there is a lot of defects you have not removed. 7 and 9. Remove the defect.
Yes, my lord, I will remove
Date.
it.
List.
My lord, also, WA copy also not served.
All right.
Copy notice has been issued. Notice has been issued. Now, over all already after the note order, last order. If copy not served, then I will serve a copy in course of the day.
Just let me see what is there.
You had been asked to serve a copy on Mr. Mahanti.
Well, in course of the day, I will serve.
Who is appearing in this matter for the opposite parties?
I'm from Siddheshwar Mahanti.
You will file objection against the petition for limitation.
That has already been allowed.
It has been already allowed.
Alright.
That's what the adjournment was saying.
I think no notice has been issued in this matter.
Notice was issued on 1st
May.
March 1,
This May 3rd order.
1st May 2023.
But you are supposed to, you have not taken notice by process, so you are supposed to supply a copy of the memorandum of appeal.
Well, in course of the day, I will serve.
All right, Mr. M.K. Kuntiala, Solution Government Advocate, appeared for the appellants and submitted that he will serve a copy of the memorandum of appeal with all enclosures to your name?
S. Patnaik. S. Patnaik. My name is not there.
Mr. S. Patnaik, who appears on instruction of Mr. Siddheshwar Mahanti and counsel for the respondent. In the course of the day, let the matter be listed again on 9th of October 2023.
You've signed in the Wakalatnama, but name has not been indicated.
Page 14, item
of number.
Yes.
So don't let instruction. Just position.
Name of the council.
It should directly clearly reflect the name of the council appealing for the respondent. Reflect the name of the council or reflect names of all the councils appealing for the respondent. Next.
Page 14, item 65. Page 15, item 66.
Lordship, this matter may kindly be taken about 2 o'clock. It is mentioned, Lordship. I mean virtual Lordship. Item 66 at 2 o'clock may kindly be taken up.
All right. This
This fixed one.
it is fixed at 2 p.m. It is fixed.
Lordship.
Page 18, item 67 to 70.
Item 68. Number 70, my lord. Before writing.
Who is that mentioning 68?
68.
You are 68.
Yes.
What is your
It's a case of selection of the post of Aspen.
problem? Is this the service is not complete?
No, I indicated with lordship's fine. In the meantime, despite that, your lordship said you take notice so that proceedings will be, service should be complete. And we have already made one. And I was at serial number 2 of the merit list.
So you have to bring this subsequent event to the record. You should file an application for accepting the subsequent facts.
Well, I'll file one by tomorrow. I'll file.
All right, whatever you file, now you need a time.
No, I want the matter to be taken up.
All right, that will be there. Just mark.
My lord, item number 69, the
Yes.
lordship has fixed this matter on 17th and 22nd August at 2 p.m. But because of hearing of other cases, this matter was not taken up on those 2 dates. And on the last occasion, your lordship had fixed to today at 2 p.m. Although it has not appeared at 2 p.m., but it has come at item number 69. So at 2 p.m., another 3 matters have been listed today.
You be there at 12:30, that we will try to take up your matter.
Obliged. So 68 can be taken up next week.
No, let us come again.
After number 17.
Yes.
Before launch, if matter will be taken up because this is selection for the post of assistant professor. Medical college.
Already tried to do that. Be there.
Page was over.
My lord,
only small matter is any payment of responsibility of the workers. It may be taken up next week.
2014 manner. It was in the list for hearing, but it could not miss. So kindly the list. And
All I will just find out in it.
my lord, IA number 214 by 2023, arising out of criminal appeal number 391 by 2014. It is being listed for hearing. But as because the other party is not turning out, the matter is not hard. So the IA number,
What's the other party?
the other party is another appellant. There are 2 appeals arising out of 2 appeals.
So you have one appeal and another appeal is there.
Yes,
Separate appeal or in the same?
separate appeal.
So that will be taken up.
So I was to be listed.
Main appeal will be displayed.
But it is not being hard. It is being listed, but it is not hard. So
Let us try.
humble solution.
Let us try.
My
All right.
Face rate appeal, my lord.
If the place just reach for it.
English matter na, read appeal. Stay of the operating against me matter. That matter is listed on 17 but could not reach matter. That was
All right. We are trying to fix it some early date, but even September, something will find out. Let us fix it. Yes.
Pardon, this is a single matter, my lord. Activities supporting the country is after this matter. But for some reason, so
Mentioned before the registered judicial. That is the practice in this.
said if the assignment is not there and if your endorsement is not there,
Just ask the registered judicial to make.
I may be pardoned to make a mention, my lord.
Yes.
There are 3 writ appeals, 1167, 1168, and 1169 of 2022. They were specifically adjourned for today only, but it has not come in the list, my lord.
Just listed to.
May I pardon to mention, my lord?
Obliged.
The modification matter, my lord, in 2012 matter. The petition against CAT matter. The petitioner challenged the petition against CAT matter, my lord.
So it is a repetition.
Petition.
When have you filed it?
That is,
When have you filed it?
I on file.
No, I know the writ petition. When have you filed it?
Revision. 2012 matter.
That matter you could not have filed now for final disposal.
That is why now, what is the urgency now? It will come according to the turn.
Some type of order.
Saying
I for modification of order for type of.
Come up to bring the file only, no? It is possible to bring the files today. Because I think it is a disposed of matter.
This was the combination of that page where the modification has to be listed before that.
And that is why I just check up the contract.
So I'm calling.
Who was the order?
On the express, we are showing the yes, Ratha.
Yes, sir. So it will go.
Yeah.
Already send it to the DL. Bye. It will come before that bench only.
Privilege, Allah. I'm pardon to mention, my lord. Please read appeal, my lord. I beg pardon, my lord. Making an unusual request, my lord. Yesterday list item 47, which I have mentioned in first hour and also in last hour. Lordship fixed it to 11:02 p.m. But subsequently, my learned friend mentioned, and it was grown to 27.
Let it be there on 27th. We'll dispose of the matter on that day.
Yes, well, on that,
On that understanding, matter has been fixed on 27th. Okay.
27th?
For disposal, come full with full preparation.
Yes. Okay. A very small prayer, Lordship. Part of matter, Lordship, it's now number 49 that rules under challenge. It can be, Lordship, fixed any day by fixing time so that it can be disposed of. Lordship, I have this matter in mind, Lordship.
All right, let 49 come because we have completed the page mentioned now. Now we'll.
Sorry, but just I'm saying for.
All right, we're taking note of that. Or send one of your associate will be there. Okay.
Lordship.
Supplementary list, fresh admission, item number 1.
May I please, your lordship, as the conducting counsel is not well, this matter may be taken up after 1 week.
What is your good name?
Amrita Naik.
Any request of MS Amrita Naik and counsel appealing to the appellant. Let the matter be listed on 9th of October 2023.
Item number 2.
It's a writ appeal challenging order passed by the Honorable Single Judge. The matter arises out of a consolidation revision on section 37 of the Orissa Consolidation and Prevention of Fragmentation of Land Act. The primary point I take before I take a look at the other matters involved here, other issues involved here. The consolidation ROA was published as back as in the year 1986. If you could kindly see page 64 of my brief. It was published in the name of our fathers, page 64, 31st of March 1986. I hope Lordship got it, madam.
Well, the publication endorsement has been made.
Well, that's at the bottom of that page. It's in a vertical
Page 64.
horizontal way. Yes, madam. Page 64, third line of that seal given at the bottom of this page, published on 31st March 1986 under the OCH and PFL Act 1973. The rules.
31st.
And will take effect from April 1986.
31st March.
Right, madam.
Yes.
Now this, it was published in the name of our fathers. Your Lordship knows, Consolidation Act, the authority has the power to determine the right title interest of the person concerned. Now it amounts to conclusively deciding the right title interest of our fathers. Now the villagers are challenging it 13 years after, before the Consolidation Authority on section 37 of the Act. Now, Consolidation Authority, without dealing with the question of limitation, if Lordship see Joint Collector Rangareddy 2015 Supreme Court says, section 37, even if do not provide an express period of limitation, the reasonable, it's a sum of the power of revision. The reasonable period of limitation is 3 years, man, for a authority to entertain application. That's well established position of law. If Lordship see Joint Collector Rangareddy para 25.
So this is the problem when the judgment fixes a statutory provision.
Right.
People do not know it because it's not a part of the statute.
Correct, do not know it. But it's only in the legal parlance, it's a judgment made law rather. As a Lordship knows, one of the law is judgment made law.
No, it's all right, but that should be well publicized when the
Correct, that should have been there.
notification
Some kind of
by the department.
Yes, they are not, they have not done it. Para 25 state your Lordship makes. Even the question of fraud is taken care of.
But what is the period of 3 years? It is not period within a reasonable period.
Reasonable period, 3 years is there, Lord. 3 years is there. But there are other judgments which say that the reasonable period is 3 years.
What is that?
But here in this judgment, immediately I am not able to show your Lordship, but I can show your Lordship. But which means there are other judgments I can show you. Would you see? Yes, it is there. My learned friend say that he can. But I'll show that, keeping that reserve before my lords, my lord.
Paragraph 31 says reasonable period.
31.
Reasonable period. There is no explanation for the delay.
Correct. Exactly. But reasonable period is 3 years. It is interpreted by some other judgments also. I can show it to my lords.
I hope those judgments, the word preferably has not been written.
Yes. That's correct, Lord. Correct.
Again, paragraph 25 says reasonable period.
Right. Reasonable period. But now question is reasonable period, my lords, their own high court judgments are there. They have said to be 3 years in case of appeal revisions and other contemporaneous statutes, Lord. They say that reasonable period is 3 years. There are other judgments. I can bring it and show it to Lordship.
All right.
But here what has happened, 13 years after revision was filed. Now the revision authority passes on.
Para 32 squarely covers your contention. There also the 13 years delay, they said this is not a reasonable time.
Reasonable. I am grateful, Lord.
So what is the learned single judge's observation?
But the Honorable single judge referring to the issue that the petitioners have failed to produce certified copy of the OA records. We had passed an order that we have our right IP interest codes. Kindly see what page 21.
Page 24.
Page 21. In fact, this may be a typographic error by the Honorable single judge at page 21. Undisputedly, 37(1) proceeding has been dismissed in absence of the petitioner. It's not dismissed. It is allowed. Petitioners, their claim through OA Act case number 4759 of 1965-66 for the opinion of this court keeping in view that the Tahsildar, in spite of finding no trace of any case record, it becomes responsibility of the opposite parties therein, the petitioners hearing, to substantiate their own case on their own and opposite parties therein. The petitioners hearing cannot blame the public authorities to substantiate their case. But we are not the petitioners before the 37 court. We are the opposite parties there. On the submission of the learned counsel that his party is unable to get certified copy of the order of the proceeding due to non-availability of such record, this court finds there is no foundation to establish the case of the petitioners and the proceeding ought to be failing for the technical dismissal of the proceeding. This court observes that when petitioners get into such copy, it will be open to the petitioners to ask the competent authority to reopen the case and go to decide on merit. Now you will also see the OA authorities ROR which was issued in favor of the settlage. Kindly see. OA authorities ROR. Kindly see page 35. It was settled under section 6(7) of the Orissa State Abolition Act. We are page 35.
Yes.
Kindly see. It is in vernacular. This settlement at the bottom of this page, OA case number 4759 of 1965-66, Faisala, decision date dated 7/1/1967. It was settled in favor of the ex-intended under section 6(7) of the OA Act. But as you knows, 6(7) of the OA Act, again it amounts to creation of a fresh title in favor of the settlers. Now, on the basis of this settlement, their litigants have alienated the property in favor of our fathers. Those sale deeds are admitted, there's no dispute about that. Now, the another question is whether consultation authority can set aside the authority that they cannot. They are bound to the settlement order. Now, what it is, Before this 37 proceeding, they are the petitioners. I am not the petitioner. I am not supposed to prove it. The villagers were the petitioners. Now they failed to produce the records. Tasdar failed to produce the records. But the case was allowed in their favor. We challenge that before the Honorable Single Judge. Honorable Single Judge placing a wrong burden, assuming that for the petitioners there, as if our case is dismissed.
No. Fraud was alleged, that is why you were asked to produce documents.
No, that is his contention. Even someone alleges fraud, the burden always lies with the person.
Yes,
alleging the
they have to prove it.
Heard Mr. P.K. Roth.
My appearance will be filed by the immediately filed it.
Arrested by MS
Adhiraj Behra.
Odhiraj Behra. Okay. But Ms. Raut has labored hard for you to take the adjournment.
In fact, I'm sorry, earlier 3 times they have taken adjournment because of my bad placement, my lord.
Odhiraj Behra.
Adhiraj Behra.
Arrested by Mr. Odhiraj Behra and counsel for the appellant. This intercourt appeal is directed against the in the order dated 11th January 2023, is passed by the Learned Single Judge in WPC number 6792 of 2020. So Mr. Roth, Learned Council has stated that way back in on 31st March 1986, way of consolidation proceeding.
That's it.
The landowner question was settled in favor of the father of the petitioners. After an inordinate delay, some villages, the respondents say the revision petition under section 37 of the
OCH and PFL Act.
Just write down the name. And the same revision was allowed, overlooking the inordinate delay that had taken place in challenging the consolidation order. Such inordinate delay cannot be overlooked by any statutory authority. And in support of that contention, Mr. Roth and Council has placed his reliance on Joint Collector Rangareddy District and another versus D. Narsingh Rao and others, :2015 3 SCC 695, where the apex court has observed as follows, quote, in as much as the notice was issued as late as on 31/12/2004, it was delayed by nearly 13 years. So no explanation has been offered even for the delay, assuming that the same ought to be counted only from the year 1991. So judged from any angle, the notice seeking to reverse the entries made half a century ago was clearly beyond reasonable time and was rightly caused. So admit the appeal to be heard on merit issue notice. Some, I think, government.
Yes, R33 to R35.
Since Mr. D.K. Mohanty, an additional government advocate, appears in notice for R33 to 35.
Yes, ma'am.
Respondents number 33 to 33, 34 and 35. No formal notice in respect of those respondents is called for. The appellant shall take steps for service of notice on the remaining respondents by registered post with AD within 7 working days from today. Notice is made and returnable on nineteenth of October 2023. You are not party in the writ petition?
That writ petition we are party. Yes.
So why have you filed an appeal to grant?
There are some persons, dead persons are there. So their legal heirs, to the extent their legal heirs, we have applied for leave. Otherwise,
you have incorporated them
yes.
already.
Yes.
All right. They just I number 546 of 2023. In view of the explanation given in this petition, we allow this petition granting leave to the appellant to incorporate the legal heirs of opposite party, the petitioner 13. Then you just point out which are those persons.
546. We are opposite party 1, 3, 8, 14 and 25.
Opposite party number
1, 3,
1, 3, 8, 14 and 25. Who passed away during pendency of what?
Writ petition there. It's against
during pendency of the writ petition. So you have incorporated already.
They are already on record. Only I have applied for.
It has been stated by Mr. Roth and Council. They are legal representative of the opposite parties number 1, 3, 8, 14 and 15 in the writ proceeding has been incorporated with the respondents in the present appeal. Therefore, no formal order of substitution is called for. In terms of the above, this application stands allowed, disposed of. Stay of operation you place in the next case.
Stay, Lord, I have nothing more to say that on that, Lord. But in my IA also there is a mistake.
Already just withdraw and file a fresh application.
File a fresh application for stay.
Mr. P.K. Roth and Senior Counsel has submitted that there is instructions to withdraw this petition for filing a fresh interlocutory application seeking stay of the operation of the imperial order. The order that has been imperial order dated 11/1/2023.
Yes.
Stands allowed. This application stands disposed of with liberty reserved to the appellant in WA number 223 of 2023 to file a fresh application seeking stay of the operation of the imperial order dated 11/1/2023.
Instead of impugned order, we will be asking stay of Annexure 7. That's the revisional order.
There is 11/3 order.
That is the order which is Annexure 7 order will be asking for stay because Annexure 1, the honorable single judge order stay will
not do anything. Okay.
Right.
Annexure 7.
We will be asking for stay of Annexure 7, the revisional authority order.
Sorry, 27/1/2010, no? Annexure 7, no? Wherever it is coming in, order will just remove. All right.
Great.
Item number 3. May appeal. It is writ appeals and appellant is still continuing service, my lords. Both the writ petitions, Annexure 7 was challenged. I will be permitted to place Annexure 7, my lords. Running page 52.
Yes.
Srimati Nirupama Misra terminated Hindi teachers Lavan Satyagraha Swamiji Purnanandam Vidyapita Puri in the district of Puri filed an appeal before this forum on 1/11/2013 through her advocate for a direction to the Secretary Managing Committee to allow her to work as a Hindi teacher. On appeal petition of the district education officer was asked to furnish a detailed report on said appeal petition
by this director letter number so and so dated 29/11/2013, and district education officer has also submitted a report by his letter number 3606 dated 11/4/2014. After receipt of a detailed report from the district education officer Puri, a decision was taken for disposal of the appeal through personal hearing of the petitioner as well as parties concerned. Accordingly, notice was issued to the concerned parties on 6/12/2014, finally on 20/12/2014. The advocate on behalf of the petitioner has submitted in his appeal petition that initially the petitioner was appointed as Hindi teachers by the office order number 09 dated 4/10/1996 of Secretary Managing Committee of the school and joined on 9/10/1996, continued as such. Accordingly, her name has been reflected on renewal recognitions form for the session 2005-6, 2006-7, 2007-8, 2008-9. But all on a sudden, she came to know that her name has not been reflected in renewal recognition form for the session 2009-10. And after that, she was prevented to sign the attendance register by the present Secretary Managing Committee. Finding no other alternative, she filed recommendations on 9/10/2010 before the District Education Officer Puri, and on such recommendation, the District Education Officer directed the Secretary Managing Committee and Headmaster of the school to explain the reason behind it by his letter number 11477 dated 10/10/10. Time and again, she filed recommendations before the District Education Officer, but no proposed steps have been taken by the District Education Officer. Further, the advocate has submitted in the appeal petition that the petition has rendered 17 years unblemished service. The present Secretary Managing Committee has prevented her only to appoint another Sri Kedarnath Sahu, who has no requisite qualifications for Hindi teachers. The District Education Officer Puri reported that the appellant was
that decision was in your favor.
My lord, that decision was favor and that was challenged. You are
challenged by whom? Management committee.
No, it by the respondent to pass the
private individual who had interest in the post.
Kedarnath was the managing committee in favor of Kedarnath.
So Kedarnath filed the
writ petitions. Also, the managing committee filed the writ petition challenging the present order, my lord, Annex 7.
All right.
So here they even they stated that they issued the so-called notice and also termination order, but the respondent directed the public originals. The
limited role in this matter.
My lord, state has supported the. It's only the order of the director was under challenge.
You are supposed to support the order of the director.
Your lordship, court has said that the order of the director was without jurisdiction because the regional director has jurisdiction in this matter.
What is the regional director? Director is not the superior authority than the regional director.
My lord, there is a circular. If your lordship has page 30. There are two circulars. One is at page 29. Quoted at page 29. That is 27th March 1983.
Page 30.
Page 29, your lordship, of the
Annex 4.
Your lordship, part of the impugned order. Annexure 1, page 29.
Annexure 1 or 4?
1, your lordship, part of the impugned order.
Okay.
The circular was issued. Your lordship has a circular?
Yes, I'm just checking. But in the paper book, it is 29 is a part of the judgment of the learned single judge.
Your lordship, I'm referring to that.
Okay, the quoted part.
Quoted part. This is circular dated 27th March 1983. And if your lordship sees over the page 30, the third line, he may file an appeal before the Director of Public Instruction, Odisha. in the case of employees of unaided recognized private colleges. And Director of Public Institutions Odisha in case of unaided recognized private high schools. Thereafter, this circular has been replaced by circular dated 15th December 2000. And in that circular, at page 31, the Lordship sees the 7th line from the top. The regional joint director has been made the appropriate authority.
Page is?
Page 31, 7th line from the top. Page 31, 7th line from the top, the concerned regional joint director shall, after giving a reasonable opportunity of being heard to the appellate and the concerned management, pass orders, and the said order of the appellate authority shall be final. And paragraph 4 says that it supersedes all previous government orders on the subject.
All right, that's all right. So according to you, also the director did not have any authority.
But the stand from the circular, it seems that the regional director, the joint director, had the jurisdiction.
All right. You are Mr. Shatyabrata Rathho. Or Mr. Shatyabrata Rathho. Counsel gets to the appellant. This intercourt appeal arises from the order dated 22nd February 2023, caused by the learned single judge in WPC 3231 of 2015 and WPC 5612 of 2015. You have challenged the one order because it's a common order.
That is a common order. Both the judgment in common order.
That is why you have filed a single appeal.
My lord.
It is a technically flawed approach. You filed another appeal also. We are admitting this appeal.
I will file it.
You filed another appeal. Stop. Mr. Rathho and counsel has made an oral application before us to treat this appeal only from the order dated 22nd February 2023, passed in WPC number 3212 of 2015. Stop. Admit. Issue notice. Since Mr. Arnav Behra, additional outstanding counsel, appears and waives notice for the respondents number 1, 2, and 3. No formal notice is called for in respect of those respondents. However, the appellant shall take steps for service of notice on the respondents number 4 and 5 by registered post with AD. Why this application has been filed? Miscellaneous application?
My lord, because the interim orders I may be removed from service. That is why I filed.
All right. Within 3 working days, no? From today. Stop. In I number 1247. Dude, I don't think you require any additional copy.
Your Lordship, not required.
All right. This is an application for staying the operation of the order dated 22/2/2023, passed in WPC number 3231 of 2015. Stop. Appeal against the said order dated 22/2/2023 has been admitted to be heard on merit. As such, we direct the opposite parties to maintain the status quo as regards the service of the appellant as on today. Stop. We grant liberty to the opposite parties number 4 and opposite parties number 4 and 5 to approach this court. Seeking alteration, modification, and cancellation of this interim order. Urgent copy. As per rule. Next.
Item number 5. Item 5.
Please, my lord. Let the appellant has challenged the order passed by the Honorable Single Judge in a disciplinary process.
October 9th October. Mr. Behra, it will be on 9th October, returnable date. Yes.
The order passed by the Honorable Single Judge in a disciplinary proceeding in which the documents appended in the memorandum of charges has not been supplied to the delinquent officer, as a result of which was not able to file a full-page written statement and participated in the inquiry.
Can you show that the documents are amended with the memorandum of charge, or
yes,
or the document were referred?
My lord.
Which one is the fact? There can be two situations. Documents are annexed but not supplied to you.
Annexed.
Are you sure? That
yes, my lord. Read it. Page 36 of the pre-petition, your lordship. Page 36 of the read petition, that the memo of evidence that annexed 3, appended in the article of charges.
Yes, come to that relevant page.
That is 36 of the read petition. These are the 7 number of documents were relied upon.
Current counsel, don't mince the word before the court when court places a very categorical question. I asked you whether the documents were annexed to the memorandum of charges and it was not supplied to you, or the documents were referred. You said no, annexed.
It was referred to in the memo of evidence.
There is a gulf of difference in connotation and mention.
My lord.
So first of all, you have no right to get this document, photocopies of this document.
No.
You have a limited right to inspect this document.
Inspect this document. I approached the authority that whether that document will be supplied to me, and they have said
that you have asked for the inspection, not supplied.
My lord. But they have said the documents are not available in office.
Where is that communication?
That communication is page 53. Annexure 8. Item number 7. The copies of the objection bills along with the objection slip.
To whom you have this applied? To the disciplinary authority or to the custodian of the documents?
The custodian of the document.
How can you apply to the custodian of the document?
No, I have applied before the authority concerned, the disciplinary authority concerned.
Where is that?
That is, my lord, page 51. I have applied before.
There is an 6.
6.
Is that the disciplinary authority?
My lord, Director of Treasury and Inspection.
Okay.
They have supplied this to the Treasury officer for supply of the documents. The Treasury officer communicated me that the documents is not available.
Okay.
I filed my written statement of defense with a plea that, my lord, after supply or inspection of this document, I will file my full-fledged written statement of defense. That has not been given to me. My lord, in the inquiry officer also, I asked for.
And what is the observation of London?
The observation of the civil judge, my lord, is para 6.1. That is info order, internal page 4, appeal page 18.
6.
Well, 6.1.
Oh.
Annexure 1 of the appeal. The observation of the Honorable Single Judge that since on the face of the letter issued under Annexure 8, that Annexure 8 is, my lord, that which they have denied the document saying that this is.
What is the order of the London Single Judge?
My lord, Annexure 1 of the appeal.
The copy of this appears it is a
Always
way number
traffic.
2151 up to
That is the office order.
You should page 15 of the writ appeal, annexure 1.
Yes, yes.
Okay.
Now come to this observation of the learned single judge in this regard.
18, page 18,
Paragraph.
paragraph 6.1.
So you filed this
Written statement
then
saying that after supply or inspection of the document, I will file my full-fledged written statement of defense. The observation of the
what is the written statement of defense?
my lord, that is page 47 of the writ petition. Second paragraph. According to the OCS CCA Rule 1962, and so, I have not yet been supplied with the extract of the records on which the allegations are based, and the list of the witness and the statement of allegations. I have been only supplied
on the page 47.
my lord. That I have specifically, I have not been supplied with the complaint stated to have been lodged in this case also. Basing upon the allegation, my lord, I was dismissed from service straight away. Thereafter, I assembled that order. And after that, the Honorable Tribunal set aside the impugned order of dismissal, this proceeding was initiated.
Yes.
My lord, in that proceeding, my lord, I asked for the documents and the particular bills which alleged to have been cancelled by me. These two bills, my lord. They have said these documents is not available in the office. Now the observation of the learned single judge is that, my lord, since I have participated in the inquiry, I have no right to challenge at this belated stage. But I have also got the notice of the appellate authority also that the non-supply of the documents I have been prejudiced.
Those documents also not placed in the Department of Proceeding?
The inquiry officer relied upon. The inquiry officer in his inquiry report have relied upon the bill number so and so you have objected.
Whether those are placed physically or not?
Not. Since those documents were not available in the office.
But it was relied in the inquiry report.
Inquiry report.
Okay. Ready for the hearing?
My lord, I need to examine this matter.
But will be taken up on 11th of September.
Your lord.
We are admitting now. Is a gross irregularity, Mr. Behra. You are Mr. Biswal?
Well,
Heard Mr. Niranjan Biswal and counsel at the appellant. By means of this intercourt appeal, the order dated 19th July 2023 passed by the learned single judge in WPC OSC number 2151 of 2016 has been challenged. Mr. Biswal and counsel has emphatically stated that documents relied for purpose of substantiating the misconduct against the appellant were not available in the department also, and such fact came to the fore when he tried to get the document, tried to inspect those documents before filing of the written statement. So even in the written statement, the appellant has clearly stated that since the documents relied on in the memo of charge was not supplied to him, he will preserve the right to file a supplementary written defense after such documents supplied to him, or he is allowed to inspect those documents. But that never happened. So even in the inquiry proceeding, those documents were not produced But the inquiring officer, having relied on the reference of this document, held the charges to be proved. Stop. Admit to be heard on merit. Since Mr. Behra and additional standing counsel, additional standing counsel appears in which notice for the respondents, no formal notice is called for. Notice is made returnable on 11th September 2023 when the matter will be taken up for disposal on merit. Stop. All right.
Item 6.
No, item 6 states agreed.
Yes.
The issue is whether the petitioner belongs to the Telenga caste under SCBC category or the Condadora caste under the scheduled tribes category. Your Lordships may kindly have page 32 of the writ appeal, which is annexure 2.
Yes.
This is the original Hal Sabik Khata from 1936.
And who has decided it?
The Tahsildar has taken an order, has passed the impugn order, Your Lordship.
Is it whether the
before the writ petition
respondent belong to the Telugu community or not? He has the authority.
Yes.
How? Regarding the status of the community, what is the Tahsildar's right? Tahsildar issued the caste certificate?
Yes, Tahsildar is the issuing authority.
You don't, Kumari Madhuri Patil is not followed in the state. There is a state level scrutiny committee. If there is any doubt, it should be referred to the state level scrutiny committee. Of course, as an issuing authority, Tahsildar may have a certain right to recall or pass any order, but ultimately, when the status is concerned, safer course is to refer to the matter to the state level scrutiny committee. Is there direction of the Supreme Court? Please take instruction. We'll take up the matter after few days about.
You'll actually fix the matter tomorrow.
Tomorrow, okay. Listen tomorrow at the request of Mr. Beheral and Additional Standing Counsel. Mr. Digabor, you're there?
Yes, my lord, but the copy will be solved.
All right.
I'll serve a copy in course of the day.
And counsel appears for the sole respondent. Stop. The sole respondent had also filed one caveat so that no interim order is passed in his presence. Since Mr. Mishra has appeared for the respondent, the caveat being number such and such stands discharged. Let the matter be listed such and such date. It is already there, no? Already. Next.
But in this case also, there was a direction from the learned single judge to the Tahsildar to decide the issue. That is at annexure 1 of the writ petition, annexure 2 of the writ petition. There was WPC 8962 of 23.
Actually, that is followed being by this old cast, old practice, that section 24 of the General Clauses Act. That who issues any certificate, he has also right to recall that certificate. Right? But after this Madhuri Patil's case,
it is the scrutiny committee which should.
Because this is the broader issues are involved in it. Yes. Maybe beyond the authority of the Tahsildar to study the anthropological background of a person, the devolution of the community to the present status, whether still acquired this the status of a backward community or the scheduled caste community. These are a specialist work. That is why usually those goes to the scrutiny committee. They can invite the specialists. They can collect the data through this vigilance cell of the state government. So, because vigilance are under their control for this limited purpose.
I'll examine this issue.
Just you see this because it is a broader issue. Not only the one issue it will be affected. So bring the instruction. Otherwise, there is no illegality because section 24 of the General Clauses Act, the general power, it is the inherent power of the person who issued the certificate to recall or to cancel that certificate. All right, you also check up the matter. That is the issue.
A copy of the
right away, I'll hand.
All right.
Item 7, deplotized.
Mr. Behavior shall supply a copy of November appeal to Mr. Digambar, Mr. and Council to respond in the course of the TGS. Item
7. May I please your lordship? My lord, in all these 5 writ petitions, my lord, in batch of writ petition, I am primarily seeking direction from your lordship that the Labour Commissioner may be directed to consider our demands with regard to the preparation of gradation list and consider our case for promotion. Because since 2014, our gradation list have not been prepared. Though all the similarly situated persons who have been appointed under Annexure 1 notification by the Orissa Service Selection Board and who are serving in other departments, their gradation list have been prepared, and the head of the department, like Director of Fishery, Director of Education, their gradation list have been prepared and they have been issued with the promotion order, but we are languishing in that stage. Therefore, my lord, my primary grievance before your lordship, without wasting your lordship time, I will request your lordship to refer to para 10 of my writ petition, because though I have made several prayers in this writ petition, I will seek liberty to your lordship not to press the prayer number 3 and 4. At this stage, our grievance can be redressed if our Annexure 8 series, where we have raised our grievances, will be considered by the Labour Commissioner, and if he is directed to take a decision within a reasonable period. Para 10, your lordship may kindly have a glance at page 8.
Yes.
Being agreed, the petitioner and his colleagues who were recruited prior to coming into force of recruitment rules 2019 and who were appointed by the Labour Commissioner Odisha submitted a series of representation on 19/1/2023 and 1/2/23 to the Labour Commissioner Odisha opinion number 2, stating inter alia that the gradation list of junior clerks was prepared in the year 2014 by the order number 804 dated 24/1/2014 by the Labour Commissioner, and thereafter no gradation lists have been prepared elsewhere. It was further elaborately submitted inter alia in the representation dated 1/2/23 that the petitioner and his colleagues were recruited through Orissa Staff Selection Commission by the advertisement number so and so in the year 59/2015 and selected through combined recruitment examination by notification so and so. Pursuant to the said notification, 18 selected candidates, including the petitioner, were posted in different field offices in the Labour Directorate, being appointed by the Labour Commissioner Odisha. Out of the same select list by notification under Annexure 1, various candidates were also posted in different field offices such as under Directorate of Fishery, STC, that is Transport Mela, but by notification dated GA Department, PG Department, dated 8/3/2019, it has been informed that the provision of junior assistants will be done by the respective collectors. More importantly, it was pointed out that after the publication of said notification dated 8/3/2019, 2 junior assistants have been promoted to senior assistant by letter number so and so dated 31/12/2019 of the Labour Commissioner Odisha. In addition to that, it was specifically pointed out that Fishery Department has prepared the gradation list of junior assistants by the office order number so and so dated 15/1/2022, who were selected under the same notification as the petitioner and promoted them as per GA and PG Department letter number so and so. And my lord, it was submitted further that since
you are not pressing this 3 and 4.
Yes, my lord. At this stage, my lord, I will request your lordship to give a direction to the Labour Commissioner to
dispose of the representation
under Annexure 8.
If you not press 3 and 4, then it will go to single bench.
All right, we can pass the order also.
They also can dispose of. That is a simple direction I am seeking the lordship.
All right, because matter has come. This even if they withdraw this petition, we can pass the order.
Yes, ma'am.
Going so much of technical, they will unnecessarily for the purpose of the.
I may challenge the others, the virus of that that at this stage, my lord, I am
not at this stage. We are writing. You will be saying this simply that you are not pressing this release.
My lord.
Otherwise, it will be continuing like that.
My lord. Annexure 8 series is my representation.
Mr. PC Chinchanil and Council appealing for the petitioner. Also heard Mr. M.K. Kuntial, an additional government advocate, appearing for the opposite party number 1, 2, and 3. So, in view of the limited prayer made by Mr. Chinchani, we do not think it is appropriate to issue notice to the opposite party number 4. Mr. Chinchani at the outset, Front Council is at the outset has submitted that he has instruction from the petitioner to not praise the reliefs at three and 4, which read as under. Just copy that page 14, 3 and 4. Stop. Mr. Chinchani has fairly submitted that if the Labour Commissioner Orissa, Government of Orissa Bhubaneswar is directed to consider their representations What is this representation?
It was 41 and 42, my lord. 8 series.
Dated 19th January 2023 and 1st February 2023. Taken an extra 8 series to the memorandum of appeal are considered for purpose of upgrading the gradation list. At this stage,
and the
gradation list
and you consider the case for promotion.
and gradation list and gradation list following the procedure, i.e. inviting objection and disposing the objections. Stop. It has been also urged by Mr. Chinchani that the opposite parties be directed to consider the promotion of the petitioner against the available vacancies in the superior grade on the basis of the newly framed gradation list. Stop. Mr. Kuntial Learned Council, an additional government advocate appearing with the opposite parties number 1 to 3 has submitted that if such direction is granted, there will be no difficulty, but adequate time should be provided to the Labour Commissioner to complete the process. 4 months' time?
Yes.
Having regard to the submission made by Mr. M.K. Panthia, we direct the Labour Commissioner to upgrade the gradation list following the procedure as indicated above within a period of 4 months from the date when the petitioner shall produce a copy of this order to the Labour Commissioner. Stop. It is needless to say when there will be vacancies available. On the basis of the gradation list, the zone of consideration shall be created, and the person within the zone of consideration shall be considered for promotion.
And the rule governing the field, my lord.
And the rule governing the field.
For promotion.
And the rule governing the promotion. Stop. They have not 19 and dispute they have not raised.
Yes, my lord. They have
done it.
Once there, he said subsequently he will again So you have said that
Because
governing the.
how can you stop someone?
No, well, that rule that I am submitting that the governing the rule.
Rules, according to the prevailing laws.
Yes, well, that.
All right. In terms of the rule, this petition stands, all the petitions are disposed of. I think this is 5 petitions are together, I get together.
Same order in all the connected cases.
All right, it will be common order.
Well,
Next.
Item number 8.
May I please, your lordship? My lord,
Yes.
here, my lord, the petitioner filed this PIL in nature of co-warrantor against the private opposite party number 3, who is unauthorizedly holding the post of Director of Acharya Hariyar of Postgraduate Institute of Cancer, Cuttack, my lord. My lord, here, my lord, kindly see the annexure 1, page 35, my lord. What is the qualification of the director, my lord? Here, according to the page 35, my lord, in annexure 1, my lord.
35.
My lord.
Yes.
My lord. Here, my lord, the second paragraph, 2, my lord, serial number 2. To be eligible for the post of director, a person must have held the post of professor with 10 years teaching experience, out of which at least 5 years as professor in an oncology center in any government, my lord, or MCI or NMC recognized medical college institute, my lord. Here, my lord, thereafter, my lord, kindly see the appointment order of the private opposite party number 3, my lord, annexure 2, page 53, my lord.
Yes.
My lord, the appointment of the opposite party number 3 in the year 2015, my lord. Here, my lord, in exercise of power conferred under Rule 22 of Chapter 3 of the Service Rule and Regulation of the Bylaw of Acharya Hariyar Regional Cancer Center, Cuttack, government has been pleased to appoint Dr. Lalatendu Sarangi, Chief Specialist Surgeon, my lord. He is a Chief Specialist Surgeon. He is not a professor, my lord. Indian Railways Cancer Institute and Research Center as Director of Acharya Hariyar Regional Cancer Institute.
Go to the recruitment rules.
My lord. My lord, page 35.
Let's go.
My lord. I am placing my lord. To be eligible for the post of director, a person must have held the post of professor with 10 years teaching experience, out of which at least 5 years in professor in an oncology center in any government or MCI or NMC recognized medical college institute. And my lord, thereafter kindly see the period of the term of the holding the post, my lord. This said the director, my lord. The director so appointed shall hold the office for term of 3 years. And the term of an incumbent director beyond the fixed tenure is extendable for another term or until attainment of age of superannuation.
But we are just concerned with the page 35, the basic qualification. We do not know because the chief servant can be also a professor there by the medical college.
Yes. My lord, may kindly see. Annexure 1 starts from page 15. It came to light only in the month of May 2021. And this annexure 2 that was issued in the year 2015. So much prior to this regulation which has been placed at page 35 that came into force. He has to produce the original rule to what was the qualification at that point of time in the
when the 35 this paragraph is 35 when it came
May 2021.
21, my lord. That is subsequent.
His appointment is prior to that
6 years. 15, my lord. My lord, 15, my lord. In the year 2015, my lord. Now he is continuing, my lord. Now
continue, obvious.
My lord, according
why
to
he is continuing, that is also reflected, my lord. We can turn to page 57. his tenure is over, and since the regular director is yet to assume the office, so as an interim arrangement, he is continuing. Page 57, my lord.
His tenure is over.
My lord, his tenure is already over, my lord. My
That
lord,
was never challenged during the appointment, when this appointment was given to the, no such a challenge was made. Now also even 2020.
You have taken the process of appointing new director.
Yes, that is, your lordship, on page 57. In continuation to this department notification number so-and-so dated 5/9/2022, the tenure of Dr. Lalatendu Sarangi, director, is extended for the further period of 3 months or till joining of the regular director.
Is there any steps for the regular appointment of the director?
That has not been done.
here, my lord.
What is your allegation? That no
My lord.
step has been taken?
No procedure, my lord. My lord, kindly.
Forget about procedure. Procedure is now no more in the service. It is a special arrangement between
Yes,
an individuals.
My lord, on that
What
basis.
do you want? That the director post should be vacant?
No, my lord.
Then
If-
what?
If there is no eligible candidate for the
That is
post
why
of
I'm
that,
asking you whether any advertisement has been issued.
So who is the eligible candidate as per you?
my lord, when there is a,
So who is the eligible candidate?
my lord, my lord, who is the eligible candidate?
Yes.
My lord, on that basis, my lord,
Do you have somebody in mind?
my lord, my lord, my lord, here, my lord, according to the bylaw of, according to the bylaw, I am placing where a vacancy in the office of the director occurs and it cannot be conveniently and expeditiously filled in accordance with provision of bylaw, the executive committee will recommended a panel of 3 names from among a senior most professor, my lord, fulfilling the eligibility of
You are
criteria.
reading from which page?
My lord, 35, my lord.
All right.
My lord, towards last, my lord, paragraph. Where a vacancy in office of director occurs and it cannot be conveniently and expeditiously filled in accordance with provision of bylaw, the executive committee will recommend a panel of 3 names from among the senior most professors fulfilling the eligibility criteria.
Paragraph
Last
My
one,
last
last one,
paragraph.
8.
where it begins.
No, so have you given that there are these candidates who fulfill the eligibility criteria? Which paragraph have you stated that these are the candidates who fulfill the eligibility criteria?
That will be decided by the executive committee, my lord.
No, decided means if there are candidates fulfilling eligibility criteria, then they will be proposed.
I have filed the present petitioner is filed this PIL, my lord.
Yes,
So
he has to
he's-
make some research.
No, my lord. He is a social activities,
I understand.
my lord.
Social activities is sometimes becomes very dangerous for the institution.
No, my lord.
Some relief is claimed before the court. But suppose we today say but you have to assert that the committee did not make out that the exercise.
Even though eligible candidates are available.
My lord, here, my lord, my humble submission.
Mr. Mudoli, that we take up the matter tomorrow. You just take an information whether this rule 8 was complied with or not.
Here, your lordship can see the rule 8 that provides that the executive committee of the institute that has to recommend to the government 3 names.
Whether that has been complied with, I'm asking.
Well, in the writ petition, there is no such averment that the
It is a
executive.
public interest litigation, Mr. Muduli. Don't take all these procedural things before us. We want to know whether that exercise has been taken or not.
That is a separate part. That is a
No,
separate.
this is not a separate part. This is a part of.
Separate institute for which we are not representing.
You take the information. It is 100% funded by the government.
Yes, they have separate council.
So take the
Separate
information.
council. They have separate council.
I am not about council. I am about you. If they refuse you to give the information, then we'll see.
Yes.
I am fixing the matter tomorrow.
OP number 1.
Day after tomorrow, huh? Is the matter day after tomorrow is parted. We have requested Mr. P.K. Muduli, an additional government advocate, who is representing the opposite party number 2, to take instruction from the opposite party number 1 whether the following provisions of the Acharya Huriyar Postgraduate Institute of Cancer Bylaws 2021 has been acted upon for recommendation for engaging a director in charge. Court, page 35, Rule 8, where a vacancy in the office of the director occurs and it cannot be conveniently and expeditiously filled in accordance with the provisions of the bylaw, the executive committee will recommend a panel of 3 names from among the senior-most professors fulfilling the eligibility criteria to the governing body for posting as the IC director till the regular director is appointed by the selection committee. Unquote. Mr. Muduri has rightly pointed out that the opposite party number 3 is no more in the regular service by a special arrangement by the notification dated. What is the date of this notification? Come to the page 56. What month?
Page 56 is 5th September 2022.
By the notification dated 5th September 2022. Stop. The said notification says that the department, health department, no?
Yes.
The health department has appointed the opposite party number 3 as the director of the said institute for an extended period of 6 months with effect from 21/9/2022. Stop. Again, by another notification dated 18/3/2023, within regularly part of annexure 5 series to this reproduction, the service, the tenure of the opposite party number 3 has been extended for a further period of 3 months with effect from 21/3/2023 till the joining of the regular director of the said institute.
Another one.
Stop. Further, by the notification dated 19/6/2023, part of annexure 5 series, the tenure was extended by another 3 months with effect from 21/6/2023 or till joining of the regular director. Stop. We would also request Mr. Muduli to take information whether the recruitment notification for filling up of the post has been issued by the competent authority in the meanwhile or not. Stop. In this writ petition,
Regular appointment to be made by the institute, but by the OP number 1.
that is why, by the governing bodies, not the governor, governing body. It has to be by the governing body.
Yes, governing body.
Or the said institute has been taken or not. Mr. S.K. Naik, Learned Counsel, appearing to the petitioner, has submitted that the very initial appointment of the opposite party number 3 was illegal as he did not conform to the requisite qualification of the post of director. Yes. But that issue has become stale in as much as the tenure of the regular appointment of the opposite party number 3 is long over. However, there is a public interest involved in respect to the appointment of a regular director of the said premium institution for the cancer treatment. Necessary order will be passed after having the information through Mr. P.K. Muduli, the copy of this order is served on Mr. Muduli in the course of the day. Showing the name of the director. Wanted as a director.
No, ma'am.
Mr.
Doctor.
Deepak Kumar Mishra. It shows in the month of May because it is not believable because issue. Maybe he has not joined. He is the professor of the Tata Medical Center.
Page 58, that was the last order that was issued in the month of June 2020.
That we have mentioned. That we have mentioned now.
Yes.
Already. Day after tomorrow it will come.
Item 9.
May I please your lordships? This is a PIL matter relating to the distress conditions of the Millennium City Cuttack because of an ongoing project JICA. In 2012, in collaboration with the Cuttack Municipal Corporation, this JICA project was started for the better.
Just remember that case. When that case.
Along with that PIL on 18th September.
18th or 14th?
No, this case is already a good. You say the other case.
Yes, that is right. 14th. ठीक है जाए She is saying 14th, but as I know that it is on 18th.
Check. Give the case number. We'll check and.
Number 2140
2140.
2020.
18th September.
18th September.
In this case, Mr. S.N. Das is appearing for OP number 3.
What go?
What? Lots of note.
He has instructed you.
He has requested me to submit.
No, that is why without instruction, don't.
Yes. He is the standing counsel of Watco.
All right, heard Srimati MS Poddalaya Mahapatra.
Yes.
Right?
Yes.
That counsel appearing for the petitioner in this public interest litigation by which it has been asked that the opposite parties number 2 and 4 in particular be directed to complete the GICA project, drain box project within time. Stop. In this regard, the petitioner has filed a representation on 28/7/2023 and issued 2 to this petition. Stop. A similar issue this court has been examining in WPC number 214, no? Is it
2140.
2140 2020. Stop. Let this public interest litigation also on 18/7/2023, 18/9/2023, when the said petition will be taken up Stop. This writ petition will be tagged with the site writ petition being WPC number 2140-2020. Stop. Mr. Mahathi, you're there?
Yes, my lord. I'm
Mr. D.K. Mahathi, Learned Counsel, appears for the opposite parties number 1, 2, 3, and 5.
One, 2,
3, and 5.
3. No, my lord. JICA, your lordship should issue.
All right. 3 is not.
No, I'm sorry. For 3 appearing, no, SN Das. OP3, Mr. SN Das is appearing.
All right. 3 and 5. 1, 2, and 5.
1, 2, and 5, correct.
So, Mr. SN Weir.
SN Das.
Mr. SN Das, Standing Counsel.
Additional standing counsel.
Appears and with notice for opposite party number 3. There is no standing counsel of Court of Orissa.
Yes, Devasis Naik, Mr. Devasis Naik. He is appearing in that case also.
All right.
Petitioner may serve copy on.
Petitioner is requested to serve the copies of the petitions to the counsel for the parties in the course of the day. All right.
Blessed.
Item number 10.
May I please, Your Lordship?
Yes.
A form of public interest litigation, my lord. The village road has been encroached by most of the persons for which there is a complaint was made before the Tahsildar, before the collector under Annexure 2, page 16. Thereafter, my lord, the collector directed the local Tahsildar to conduct an demarcation over the village road. Accordingly, the RI conducted the demarcation and found that there is 20 foot and 30 foot road, but it has not been, if a four-wheeler is not passing the village road. Even if there is a report that yes, that is the business status of the, but no action has been taken.
Report is Annexure 3.
In Annexure 3. That is the.
Mr. Mohanty, what is happening?
What is report? Annexure 3. Yes.
Page 17. And thereafter also we have intimated the said fact before the collector by Annexure 4.
What is there in the report Annexure 3?
Actually, directly collector to
take action
on the basis of the RI report.
Heard Mr. Pranav Ranjan Chatoi, Learned Counsel, appearing for the petitioners. The petitioner is a public spirited, petitioners are the public spirited individuals living in the village of Kushinda under district Cuttack.
My lord, in the RI report, there is no finding of any encroachment. Your lordship, this is in vernacular.
Yes.
Could you just?
I am not saying that they are demarcated, but in fact.
Just read out, that is difficult to read.
I can read.
The full handwriting.
Yes, I can read, but there is no encroachment. He has only demarcated the road.
Yes, as well on the basis of this is a demarcation report.
Yes,
yes.
If any encroachment is found, we will be directing the collector to remove those encroachments from the public road.
Then your lordship may directly Tahsildar, because that will can be implemented in a better manner. The order. Tahsildar, yes, Tahsildar Parunga.
All right. Oh. Asked by means of these public interest litigations, the program is asked to remove the encroachment over the Kushinda road under Moja Kanhipada. Kunhipada. Pertaining to Khata number 331, plot number 1192, with an area of 0.102 of decimal under Boron Tahsil stuff. Mr. Chotri Land Council has drawn our attention to the report of the Revenue Inspector dated
2nd February 2023.
2nd February 2023. It's a demarcation report showing the position of the road. Stop. The petitioners filed the representation lastly on
4th April
2023 to the collector.
Cuttack.
तहसीलदार को दिया ही नहीं
With a copy to the
कॉपी टू तहसीलदार बारंग
And there is a lastly, what is this address to the cutter?
Collector, I have addressed to the collector, which are happy to Tahsildar.
Urging the collector Kochok to take action on the basis of the said report and make the road encroachment free. But the allegations of the petitioner is that no action has been taken on the basis of the said encroachment, on the basis of the said demarcation report submitted by the revenue inspector. Mr. D.K. Mohantil, an additional government advocate appearing for the opposite parties, has stated that in the report of the revenue inspector, there is no mention of any encroachment. Stop. Be that as it may, we direct opposite parties number 2 and 3 to take quick action to remove the encroachment, if any, on the basis of the report of the revenue inspector, Annexure 3, within a period of 7 days from today.
Under 7 days. Or cement give because they have to be noticed. If there is any encroachers are found, they are to be noticed.
Road also they receive notice.
There is a distinction between the Section 4 and Section 6 of the Illegal Occupants Act.
Yes.
When it is a proceeding under 6 that you need to give notice, and illegal structures on the public road is copying under Section 4,
yes,
you have to give any notice.
15 days time may be given, so that is
within a period of 15 days from the date of
production of the order by the petitioner.
The date of the receiving the order, copy of this order from the petitioners. As a matter of abundant caution, a copy of this order be supplied to Mr. D.K. Mohantil, an additional government advocate for onward transmission.
Yes, I will transmit.
So in terms of the above, this petition stands disposed of. Next. Call.
No, one is double BCRF.
Got to.
Item number 12.
I may please, your lords. This case, my lord, this is a public interest litigation. The petitioner has challenged the inaction of the authorities in cleaning the area, which there has been by channelizing the drain, which has caused stagnation of wastewater, drain water in the locality.
Yes.
Gopinath Vihar area of both township. The petitioner and other residents of the locality approached different authorities and made representation also to the collector, but no step has been taken. It has created an unhygienic condition in the locality. It has been a breeding center for mosquitoes nowadays, dengue, malaria, that is your lordship knows. So my approach to different authorities has not been responded to. The last representation was made Annexure 3, my lord, that is vernacular.
Yes.
31/7/2023. But the administration has not taken any step to channelize the drain water. A drain is being constructed by the NSC, but there is no outlet. Since there is no outlet, there has been stagnation.
Respondent number 7, you have made him a party.
Respondent number 7 is a private person, my lord. The drain was in fact channelized to the dead canal. And the dead canal is being obstructed by respondent number 7, for which the drain water is not flowing. Therefore, a complaint was also lodged against him.
We'll only ask to draw up a proceeding to remove the obstruction and taken a holistic view how the rainwater and other the foul water, those are flowing through the drain, can be channelized properly so that this doesn't become a breeding ground for the mosquitoes. And for that purpose, if the occupation of the 7 is there, they will issue notice on the spot of the 7. Yes. You are Mr. Mishra.
Yes.
Heard Mr. Vibhuti Bhushan Mistral and counsel appearing for the petition. By means of this public interest litigation, the petitioner, who is a public spirited individual, has asked this court directing the opposite parties to take appropriate action so that the unhygienic situation that has been generated from the stagnation of the wastewater and the rainwater in the locality called Gopinath Bihar, under both township, can be addressed to an appropriate public health measure are taken. So it has been also alleged that a part of the drain, part of the channel to the end has been illegally occupied by the opposite party number 7. And therefore the flow of the water has been seriously obstructed. Stop. Mr. Mistral and counsel has submitted that the petitioner had filed one representation on 10th April 2023, Annexure 2, to the petition, and thereafter, before approaching this court, another representation of 31st July 2023, but without any yield whatsoever. Stop. We have also heard Mr. HON'BLE Beharal and additional standing counsel appearing for the opposite party number 1 to 6. Stop. Having appreciated the submissions of the counsel for the parties, we direct the opposite party numbers 2 and 4 in particular to take a coordinated action to remove the obstruction of the rain or its channels leading to the end for obstruction-free discharge and flow of the wastewater and the rainwater, so that the said drain doesn't become the breeding hub of the mosquitoes. Stop. That apart, stagnated water is always harmful, as the noxious gas can be formed from the said stagnated waters. And these are the common knowledge. Stop. We direct, therefore, the opposite party number 2, the collector both, and the executive officer, both called NSC. That is, NSC means Notified Area Committee.
Notified Area Council.
NSC to take immediate action to remove any obstruction in the drain and to take other actions to make the and also through the other actions so that the flow of water through the drain is not obstructed anywhere. Stop. Necessary repair. If any repair, if any, is required, that shall also be done simultaneously. Stop. Such action shall be completed within a period of 30 days from the date when a copy of this order will be supplied to those opposite party by the petitioner. However, as an abundant caution, we direct the registry to supply a free copy of this order to Mr. Behral and additional standing counsel for onward transmission.
Item 13.
Lordship, in this matter, I am for the petitioner. Lordship, my
54. Yes, Mr. Naik. You lost before this single judge also.
No.
Make a short submission. Where is the order is inform or it is suffering from some faults? Just show that first, then you can elaborate.
My lord, the Honorable Single Judge has dismissed the matter only on the ground that the appointment was illegal. Although it is not actually illegal, it may be irregular, but it is never illegal. My lord, he mentioned it as illegal because the appellant was appointed.
You come to the paragraph 3 of the judgment.
My lord.
There is a mention that you approached the court earlier also.
Yes, ma'am.
And on view of the direction of the earlier order, serious efforts was taken and inquiry was made, and thereafter your representation was dismissed.
Yes, ma'am. No inquiry was made.
No, the inquiry means the representation consideration. Yes.
We have the order in the previous petition was that.
What is that order?
Order, my lord, in the previous petition to dispose of the representation of the.
That is the order.
Yes, ma'am.
All right. Now come to the annexure 1 also.
Yes, ma'am.
Yes. So what is your right? They have clearly mentioned the 14 days engagement with a break of 1 day. You accepted that. And regularization.
The poor lady having its
he is all right, but the question of legalization and that has been decided by all the decision of the Supreme Court. You see, and there is a very specific case that there was no continuous service also. It is a really paining. Because of some people cannot also bargain in the situation, and Mr. Kuntia and his government thinks that is the opportunity they will take always to exploit the poor people. They will not fill up the post when there is a regular vacancy is available. Now the court can help it out.
My lord.
The right of the court can just make these things.
My lord, they break after 44 days, you are watching that it is technical
that is why you have an agreement. No, you don't bring these labor acts principles where these owners or the employers doesn't allow someone to complete 240 days. And only all the decision of the Supreme Court, you will find that over 236 days, 237 days, there was a mechanical break, and the Supreme Court says those are merely mechanical breaks, we are ignoring it. This is not a case because they have already advertised. You knew that after 44 days, you are going to be a break of 1 day. You can say it is mechanical, but it's an agreement. You accepted the terms and condition.
Of course, my lord, because there is no other way for the appellant. And my lord, you logically see Annexure 2, my lord.
Yes.
That 1 day they have also been dictated. It has not been there. Annexure 2. When she was transferred to the girls' school, Where are doing this?
Okay.
He was transferred.
How you are appointed?
96 number, 2696.
No, how? Because it appears that there was no selection process, nothing of that sort.
I don't know, my lord.
No, because this is the basic fact. Because Uma Devi will come immediately into operation. 2006 Supreme Court, paragraph 53, judgment. You know what is the observation of the Supreme Court? And this particular part was never touched by any judgment, even the 2018 decision of the Supreme Court, where it says that someone was not considered according to the Umadevi's stipulation of the 10 years completed and the special kit should be there. That is not the end of the term. That can be also extended by any government for consideration. Those people has put in 10 years silence. But here is a question that you are not regularly appointed, and that is the what Lord Single Judge has noted and dismissed your petition.
That's to it. And there is no aberrant in the rate with some that he was, after being duly selected, he was engaged.
That is why. That is the.
There is no record so far available.
When there is no record means there was no selection process. Selection process, there should be record.
So that's
part of the public records.
My lord, your lordship, she was allowed to continue for long 27 years. And after 27 years, they have just taken back the service given by them and did not allow detention to the poor lady who is having two grown-up daughters.
Just that is why I'm asking you, just go to the Umadevi. Umadevi says no right. Illegal appointments or illegal appointments.
This is not illegal, my lord.
No, just wait. Why not illegal? Why is the transposition process of selecting someone? And if that is not conformed to, that is illegal. Umadevi has made a distinction between the illegal appointments and the irregular appointments.
Yes, my lord.
You see that distinction, and the category that has been created by the Umadevi in 2006 is still valid law, and you come within the category of the illegal appointment.
But actually, that is not illegal. It may be irregular, but not illegal because
no, because someone appointed without following any selection process.
But there is no role of the appellant.
The rule of the appointment, appellant. There must be the rule for recruitment. You cannot say there is no rule, but the rule was flouted. It is apparent on the face of the record.
But there was no rule at that time.
Cannot be. If there is no rule, there must be the executive instructions. This is the qualification. This is the age. This is the experience required for any post. That three essential things should be there, either by your rules under 309 proviso or by the under Article 162, the executive instruction.
But she was appointed.
Understand, I'm 100% with you. So far, you are talking about the empathy. But problem is that the jurisprudence that has been developing from the Umadevi, nowhere there is any rule for the court. Earlier, we used to direct, consider, and regularize because of this. Now, we can become in a tight corner. The court has to act within the four corners of this direction and the rules. Near the longer year you have said, that cannot be a ground for directing any government for regularization. And in the first writ petition, the direction was given to consider you. The similar fact, the direction was the government considered, said we cannot give you any appointment on regular basis. Recently, Supreme Court has reversed one order passed by the Chhattisgarh High Court, where this sympathy swayed the judge and he passed the 31 years he was regularly working, giving the regular appointment. Supreme Court says the court doesn't have any authority to give such direction. You find the court's difficulties also. This is definitely, we do not support this kind of employment. But this is happening, and we have to act within the four corners of the law. Otherwise, we can repeat the second time representation. It will not lead us to nowhere. You think over, if you want time, if you want to study Uma Devi, if you can find out. I tell you, there is a lot of decisions before this 2006 judgment. One of such judgment is the Kerala Water Commission. When a person served for 8 years, Supreme Court directed, give him the regular appointment. But these laws are no more enforced because of this larger decision in Uma Devi. I think better you pursue the government.
She has already retired from this.
No, that is why there is no question of retirement because you are not holding any substantial post. So you can request the government whether they can provide you some sustenance on the consideration. That is a separate cause that I have worked for such a long time. I did not get any benefit when my service was disengaged. So whether the government can consider this my service and on the basis of any lump sum amount or the lump sum monthly pension can be granted to me. The government can exercise the discretion. The court cannot. I think that would be, you just withdraw this appeal and go to the government for a different cause. Don't seek regularization. Regularization cannot be done because you are out of service.
Regulation on national basis, sir.
Letting highlight it. You know that what is the regulation does mean. The government has to find out a fund unless the post is available. And in the writ petition I was reading, there is no assertion that against a regular post this lady was working. That is also not there. Because you did not know whether there was any regular post and against it that was entertained.
But my lord, the language mentioned.
I'm saying just show the language. I will allow you to reread the language.
Reading one into both.
Just read the language. I'm not in a hurry. You just convinced me. These aspects I'm.
The first appeal introduced.
Not a single order there is any mention of the financial code, post code, nothing of that sort is there.
But if you are appointed on
all right, we are doing one thing, that we are dismissing the appeal, giving you liberty to approach the government, whether the government can accommodate with you the lump sum financial assistance or the lump sum monthly, the financial assistance.
Government is not so kind, so the government would not be.
That is the difficult thing. Kindness, everybody asks from the court, and court cannot work without the power of the law.
But my lord, once the case is dismissed, the government is not going to consider anything.
We are observing categorically that you can observe the government.
Instance in this, in state and also in this court, my lord, where the case has been dismissed by the honorable court and they have considered for a lump sum amount or whatever it may be.
That is not true everywhere.
If he withdraws and file an application, that can be considered. Let him withdraw the case.
Case and ask for on the basis of your service for the 27 years.
Yes,
that I have not received anything at the end of my service.
Yes.
Now I am in a hapless situation. In considering of my 27 years of service, you ask the government to provide you some lump sum assistance in the form of the retirement benefits. Government may not consider, but that is the only avenue is available to you.
But Mr. Khuntia, the government advocate has also, additional government has given some schemes made by government regarding to our those. First thing is annual employees. Another is temporary status. The temporary status, my lord, that has been there.
No more in the job. How can the temporary status even can be granted to you? These status are not to be given notionally. So this is the way we are asking you. It is up to you, because we do not find any space to intervene in the judgment. When the government has already considered your case in view of the order passed in the first writ petition. That is where we are at now. So we can observe if you want, otherwise we can pass the usual orders that we pass.
But the government, the order passed by the government has also been passed by the Honorable Civil Judge also, because that was that she has not been appointed in a sanctioned post, and she was not the authority was given her appointment has not taken permission from his superior authority. These are two points they have mentioned in the rejection of the first representation. That is, Your Lordship, you can consider whether she was continuing a vacant post or not.
How can? You have not placed any materials.
Annexure 1 and 2.
Read that you can show that she was appointed against a vacant post.
Continuing, I don't know, appointment.
Continuous doesn't mean anything now after Uma Devi's case. I am just pointing out that Uma Devi is a larger bench decision. I am telling you the Kerala Water Commission's case, there was 8 years and Supreme Court directed for regular appointment. But with the changing times after 1991, the philosophy in the labor law has also changed.
The persons who were appointed on contractual basis also, they were subsequently regularized, but they are not getting any scale of pay. But in this case, the appellant was getting a regular scale of pay, but has not been regularized. But in case of contractual employees, they were having some consolidated pay, but they have been regularized.
You know why they have been regularized? You know better than me. The government has taken a decision in the state cabinet that will regularize all of them. That is equivalent to formulating a scheme.
That is a policy decision of the government.
That is why there is a equivalent to a scheme. Already you are passing the order, we will be making some observation. Always. So, Mr. Arin Naik, Learned Counsel, appearing for the appellant, and also Mr. M.K. Kuntial, an additional government advocate, appearing for the respondents. By means of this intercourt appeal, the order dated 20th September 2022, passed by the learned single judge in WPC number 39394 of 2022 has been challenged. By the said order, learned single judge has observed that the appellant has rendered more than 25 years of service as class 4 employee, then became peon in MS High School, Baramba, and the Government High School, Badamba, on ad hoc basis. So, It is also stated by learned single judge in his order that appellant was getting the regular scale as it was she or he. She was on ad hoc, appointed on, engaged on ad hoc basis. So, according to the government, according to the opposite respondents, the appellant continued in the service on 44 days basis with 1 day break in between two spells of the appointment. So, forward. But counsel for the appellant has stated that from the order dated May 2001, it will be apparent that the appellant was allowed to continue against the existing vacancy until further orders. So, we have carefully examined the said order, and we find that terms and condition was similar to that of the first engagement order dated 12th June 1996. So, but true it is that the petitioner was serving against an existing vacancy. Stop. But having no right of regularization. For that reason, the appellant filed a writ petition earlier and that writ petition was disposed of, directing the authorities to consider the representation of the petitioner for purpose of regularization of the surface. Stop. Now, a single judge, while dismissing the writ petition, has observed inter alia that the appointment of the petitioner, within bracket the appellant herein, and continuance in the service in non-sanctioned post is beyond the rules, and no procedures have been followed to appoint in order to fill up the Group D post. The petitioner was appointed on 44 days basis and it was extended from time to time with 1 day break and received salary meant for the ad hoc peon post. He also revised, she also got the revised scale of pay in a minimum scale under Orissa revised scale ORSP rules 2008 as per the Finance Department resolution dated 21/10/2010. Having referred to the state of Karnataka versus Umadevi 2006, I find out this citation. To 2006 4 SCC 101. We can further observe that service of a person who has been cannot be regularized solely on the basis of the longer tenure that he or she has served if the appointment is illegal. So, according to the learned civil judge, the appointment of the appellant is illegal. Stop. The state observation has been seriously criticized by Mr. Naik and counsel according to the appellant. Stop. Mr. Naik and counsel has submitted that if the appointment was illegal, how the authorities allowed the appellant to serve for such a longer time. He has also referred to the Umadevi's prescription, where it has been stated that whenever an appointment is discovered to be illegal, immediate action of termination or disengagement has to be taken. He asked this court on the basis of the said analogy to draw the inference that the appointment was not illegal. It may be irregular, and according to Mr. Naik, in Umadevi, it has been observed that irregular appointments which are older than the 10 years should be considered for regularization. Stop. From the other side, Mr. Kunthiel and additional government advocate has submitted that the term of such service is immaterial when very categorically it has been provided that after a period of each 44 days, the service will face a break of 1 day. Stop. That apart, Mr. Kunthiel and counsel has pointed out that the appellant is already retired from the service. And this says there is no question of regularization. Stop. At this juncture, Mr. Naik London Council has strenuously urged this court to direct the opposite parties to give the notional regularization. Stop. Having appreciated the attending facts, we do not find any substance in the submission made by Mr. Naik for notional regularization. Such notional regulation can be directed by a court only when there is a scheme in place and it has the force to be treated as creating quasi right on the post, but this is not the case in the present case. Therefore, we reject that contention. However, we find sufficient force in the submission of Mr. Naik that the petitioner, the appellant, has served for 27 years on an ad hoc post, enjoying the benefit of the scale and other benefits like regular employees. Therefore, for the period she served, there cannot be any area benefits. So far the pay and allowances is concerned. What we have distressed us that after rendering 27 years of service, the appellant did not get any post-retirement benefit because of her status as the ad hoc employee. So in absence of any law, the court cannot direct the authorities to release any retirement benefit like pension, gratuity, etc. Unless an employee is in the regular establishment, the benefit of the gratuity also cannot be redirected. But we direct the opposite parties to consider opposite party number. Actually, it will be the
one real is direct governments that consider.
Secretary. Direct the opposite party number 1 to consider the long tenure of the appellant and take a decision on human consideration whether any lump sum retirement benefit can be given to the appellant or not. For this purpose, the appellant shall file a representation. As such prayer was never made by the appellant before the respondent number 1 or the other respondents, the representation shall be filed by the appellant within a period of 15 days from today with a copy of this order. Stop. Having on receipt of such representation, respondent number 1 shall decide the prayer in the representation within a period of 2 months. Stop. We would further observe that at the time of consideration, the respondent number 1 shall take into the respondent number 1 shall consider the term of the service, long term of the service the appellant is rendered at the time of consideration. Stop. We think that the consideration should be human consideration. Stop. The above observation, subject to the above observation as made by us, this appeal stands disposed of. A copy of this order be supplied to Mr. Kuntial and counsel appearing for the opposite parties. Yes. All on matches. Huh? This person order.
Item 69, sir. 1231.
I may kindly permitted, my lords. My lords, the present writ appeal has arisen out of the judgment and order dated 1st May 2023 is passed by the Honorable Single Judge in writ petition number 9850 of 2012.
Yes.
Before placing the relevant materials, that is, what were the material before the Honorable Single Judge and what were the grounds of challenge by the petitioner and what were the substantiation by the opposite parties and what the Honorable Single Judge held and to what extent the order of the Honorable Single Judge is liable to be set aside. I want to place before your lordships a short synopsis of this case. And my lords, the crux of the
it is a written synopsis.
Hello?
Is it a written synopsis? Give this synopsis to us. We will continue this matter day after tomorrow, making it parted.
My lord.
All right. Third Mr. P. Tripathi, then counsel, Mr. Mistral, both of you are appearing here.
My lord.
And Mr. A. Mistral and counsel appearing for the appellant. Heard in part, release the matter day after tomorrow, no? As parted for continuation of hearing. Who is appearing in this matter?
BDA, lordship, we are serving a copy to him. BDA is appearing.
Who appearing? All right. You are appearing for Mr. Mahapatra?
Yes, my lord. This matter was listed as item number 69 and indicating to be heard at 2 p.m., my lord.
No, it's not hard at tomorrow. We are fixing it on day after tomorrow.
Yeah.
All right. Well, I just forgot your name. What is your name?
Jyotirmay Barik.
Mr. J. Barik, Learned Counsel, has appeared for the respondent, Bhubaneswar Development Authority, on behalf of Mr. Dayanand Mahapatra, Learned Counsel. Okay.
Your lordship, my lord, may kindly also record that we are submitting the synopsis.
Synopsis,
giving a copy also. And the short points, your lordship, of argument.
The note of submission along with synopsis of the argument has been filed by Mr. Minister and counsel for that appellant. Those are taken on record. Item 7. Just wait. We have 2 matters fixed, and after that we'll try to accommodate you. Okay.
Item number 58.
Yes, madam. I may be permitted to argue on this side. It is in private capacity I am arguing this matter, but that side Madam is sitting. So yes, this appeal is directed against the judgment passed by the Honorable Single Judge. That is, your Lordship may see page 24 of the memo, order dated 13/9/2022. Page 24 of the appeal memo. This is the impugned order of the Honorable Single Judge.
This is a very short judgment.
It's very short judgment, and I will only place one point. I will not go to the merit of the case. If your Lordship will see that the Honorable Single Judge is justified in disposing of the writ petition in absence of the petitioner, and when the sole petitioner is dead on the date of hearing of the case, and the substitution application is pending, without allowing the substitution, without hearing the legal error, the Honorable Single Judge has allowed the appeal, allowed the writ petition. That is the main ground which your Lordship may see. Dismissed the writ petition. Okay. Disposed of the writ petition.
All right.
Anyway, she is saying dismissed, I say disposed of. And it is against the petitioner. That is not reflected in the order. Let me place before your Lordship the order number 1 passed in this appeal. Your Lordship, in this appeal, order number 1, dated 4/4/2023. It is pointed out by Mr. T.K. Mahantil on counsel appealing for the appellant that although the petitioner had expired during the pendency of the WPC number so and so, and a substitution application to bring on record his legal representatives was already filed and numbered as IN number so and so, the impugned order of the learned single judge does not notice the above fact and proceeds to dismiss the writ petition, noting that the SOP in question.
One thing that we follow that very rigid principles regarding the
That I will place a decision of the honorable
counsel for the petitioner is not there. Petitioner is not there. We dismissed this for non-prosecution. You do not make any observation on merit because it is not fair procedure. Someone is not there without giving any opportunity to that person or the lawyer. We should not make any observation on merit. Good or right, whether
the counsel for the petitioner was present. The counsel for the petitioner was present.
That is,
but my lord, the learned single judge what did, my lord? They have filed an application for substitution because the sole petitioner was at that time dead.
Person.
Hello, without substitution.
Yes, my case. I think
Yes.
So, admittedly,
I think Ms. Mohapatra is supporting your case.
Then I am obliged to her. Admittedly,
you submitted that without entertaining the substitution petition, the writ petition has been disposed of.
Yes.
Knowing fully well the petitioner is dead.
Yes, my lord. And in this regard, a decision I am placing before law.
Decision is required. Yes. That is what Ms. Mohapatra.
And it is a nullity. It is a nullity.
It is not a knowledge. Again, you cannot adjudicate a matter relating to a dead person.
Yes, my lord.
It is a simple principle.
And that is why your lordship will see the Honorable Chief Justice by order dated this number 1, while issuing the notice to the respondent, had directed the status quo as was prevailing during pendency of the writ petition will continue. During the pendency of the writ petition, what was the position that will continue? That is the specific direction of the. So my only point, reference before your lordship is that admittedly the petitioner was dead, substitution petition was filed, and substitution, to praise the substitution petition, the advocate who was appearing for the petitioner before his death, he appeared, but without hearing that, without considering the substitution petition, which is annexed to my writ appeal also, the Honorable Court has disposed of the dismissed.
That can be the two remedies now, since I think you also could not file any counter affidavit. You are appealing for the opposite party number 4.
I filed my counter.
Yes, I'll do exhaustive counter affidavit thing. But I am not going to the merit of the case because on merit,
there can be the two approaches, Mr. Mohanty. One, that we remit the matter back for the substitution and proceeding takes place before the other.
That is
entertaining the substitution here. We heard the matter on merit in the appeal.
But then I first
you agree. Otherwise,
no. I think the first proposal what your lordship is giving, that is
if you do not agree, we will not entertain this kind of. That we are pointing at.
remanding the matter to the and allowing this over, then here the matter, then otherwise I will lose another.
Then, my lord, I will place my case, my
You
lord.
are not in jeopardy.
No, because of the fact that, my lord,
Yes.
there are two writ applications. One was filed by my lord and brother's client, and another one was filed by me. In that writ application, I have claimed to, my lord, allotment, everything has been done, owing to beginning. Because of the interim order passed, it was not allotted in my favor. All the procedures have been followed.
All right. But that interim order.
After dismissing this writ application, my writ application was entertained and direction was issued because of the interim order, you have not proceeded, you can proceed. That order they have not challenged. By virtue of that order, my lord, the sovereign has already been allotted in my favor. And because of this interim order, my lord, I have my lord spent more than 20 lakhs. I have given the areas of the earlier reality.
We are not entering into
No, I am also not because of the fact.
So that writ petition is disposed of.
Disposed of himself.
See, that is also very interesting. See, in that case, I was included as a party in handwritten. That is there I am just placing, but no notice was issued to me.
Notice was issued that appeared, when substitution has noted. Because when that order is also that order has already been implemented.
Yes. So you are expressing your worry. There is nothing to worry.
No, I am expressing my worry.
And what was
because of the interim order, because of the interim order, they are not executing the my lord agreement. And I am not getting sorry.
Yes, we are when remit the matter, this interim order will definitely vacate.
And second thing, my lord, the substituted legal heir is the mother of the LOT.
Maybe.
Mother has the right to be substituted.
Yes, my lord, he is class 1 here. I am disputing that, my lord.
Then?
Only thing, my lord, I am saying that his son, her son, have got two sovereigns in the same.
Oh, but so you are attention to one document only. You may see the counter affidavit of the respondent dated 27th June 2020.
We are not entering into merit. We simply remitting the matter back to the legislative judge after quashing the order. And then you take the appropriate steps. You move your application for substitution.
That is pending.
That is what we are not doing. How that can be pending when the main this
once it is revived means that will also, that is my disposition. I will also revive.
My lord, the alternative thing what your lordship has done, lordship also can have this matter on the
He's not agreeing. I cannot do that.
But in the other writ petition, you have not been substituted.
That is what I was placing. My lord says that I will not.
That is challenged here, so why should we look into that?
That is also not challenged. That is also not substituted.
No, that is not challenged here. That order.
That is this is main writ. That is
Heard Mr. D.K. Mohanty, Learned Counsel, appearing for the appellant. Also heard M.S. D. Mahapatra, Learned Counsel, appearing for the respondent number 3. Mr. Mahapatra is there? No, you are on behalf of Mr. Yes, Mr. J. Bari, Learned Counsel, appears for the respondent number 1.
No, I am respondent number 4, my lord.
You are not. You filed the Bhugalat number for 3.
4, my lord. That is Kaushal Sharma. Kaushal Sharma, my lord.
She is appearing for respondent number 4, I think.
It should be, I think.
I have filed the Bhugalat.
Is for respondent number 4.
My
last order also we corrected it. But the Bhugalat, I think you have written respondent number 3. Ms. Mahapatra is Bhugalat number 3.
Kaushal Sharma is respondent number 4.
is on behalf of Fakir Mohan Sharma, that is respondent number 3.
Okay, more Sharma.
Fakir Mohan Sahu.
Respondent number 4 is Kaushal Sharma.
Kaushal Sharma, respondent number 4.
You Google it now in the sleep.
Kaushal Karma Sharma. Fakir Mohan, Kaushal
Fakir is opposite respondent.
Kaushal Karma Sharma. Opposite partner 3 and 4 year lot. Respondent number 3 and 4.
But if you have not appeared, how can we say?
I have
That is not there for Kaushal. Your lordship may right? Only the on is presented.
No, lordship kindly see Kaushal.
All the affidavits are by Kaushal Sharma, but Rathod is not there. No, nahi. देखो ना
देखी सारी चीज
Both the was executed by
Kaushal Sharma first, thereafter Fakir Sharma.
Thereafter means 2 Wakalatnamas.
No, one of these then have happened.
both abstained. Corresponding with 3 and 4. So, by means of this intercourt appeal, the appellant has challenged. Appellant is the son of the original writ petitioner.
Mother of the deceased original petitioner, deceased sole petitioner.
No, who is Pradeep Kumar Sahu?
He is the deceased petitioner.
Okay.
Now the applicant is Parvati Sahu.
By means of this intercourt appeal, the appellant, mother of the writ petitioner, has challenged the order dated.
I don't write the deceased writ petitioner because he is dead.
Mother of the deceased writ petitioner has challenged the order dated. Have you taken leave of the court?
Yes.
Have you taken leave of the court?
No, I have not, because as the legal heir, I have filed the appeal.
No.
Without substitution, this is the rule. You have to take leave of the court.
Yes,
because the court doesn't know because there is no substitution. All right. Challenge the order dated 13/9/2022 as passed by learned single judge in WPC number 14046 of 2020. So at the outset, Mr. Mohantil and counsel has stated that since the original writ petition was her son, she has filed this appeal. However, inadvertently, no writ petition has been filed in this court. Stop. We grant the leave on oral application of Mr. Mohantil and counsel for the appellant. By the order dated 13/9/2020, the learned single judge has observed inter alia that the writ petition has been brought only at the state of pendency of the application at the instance of the petitioner, and also making a claim in respect to the shop room involved therein. In pendency of the representation before the competent authority, this court first finds there is no scope for entertaining any such writ petition, secondly, for petitioner involving all the developments taken place in the meantime, creating a right in favor of the opposite party number 4, there is no otherwise possibility of interference in the decision process. Stop this, just code, make it in the italics. Just within bracket as verbatim, as in the order. So this I just sort out or make it appropriate order. Stop. Mr. Mohantil counsel has submitted that when the order dated 13/9/2020 was passed, the original petition had passed away, and there was an application pending for substitution.
By the IN number 8178 of
Substitution by the IN number
8178 of 2022.
8178 of 2022 by his legal representative.
By the appellant.
Stop. Learned civil judge without allowing the legal representative to be substituted in place of the deceased petitioner has passed that order. Stop. On the other side, Ms. D. Mahapatra, learned counsel appearing for the opposite parties number, respondents number 3 and 4 has stated that learned counsel for the petitioner was present in the proceeding and it says no prejudice as such has been caused in the interest of the original petition. Having appreciated the attending facts leading to the impugned order dated 39/2022, we are of the view the procedure that has been followed by the learned single judge cannot be appreciated, cannot be accepted. Stop. As such, we set aside the order dated 13/9/2022 and remit this writ petition back for the reconsideration. Before the writ petitioner is disposed of, the interlocutory application being IN number such and such, which had been filed for substitution, shall be taken up first. Even the respondents number 3 and 4. Have you received a copy?
Copy of the substitution petition, my lord. Yes, madam.
All right, taken up first. Later on, the writ petition will be heard.
We'll serve CDA. No, CDA counsel will serve.
Mr. Mohanty Learned Counsel has undertaken before this court that he will serve a copy of the interlocutory application for substitution to the counsel to the opposite party number 1 in the writ petition. So, accordingly, this retail stands allowed. Interim order, if any, has passed in this proceeding, stands vacated.
My lord, there was an interim order in the writ petition. That was still disposal of.
No, all right, it will be revived.
That your lordship may observe that the interim order passed in the writ petition is revived.
All right, on application.
No, your lordship, why not? Then some debate is taken.
Yes, sir. The recording of this that is going on, I will print those in the order.
Sorry.
That you shouted this.
No, sorry, ma'am.
The on application of the writ petition, the interim order, if any, in the writ petition may be survived, subject to given scope of hearing to the opposite party.
No, that was passed on merit.
All right, it will be revived on your application. Yes. It is after a long gap. What is happening there? You file your application, that you revive it. I have observed it will be revived on your application.
But till then,
nothing else. Tomorrow you file it. You got the order today only. Right?
My lord,
think of this order is
because they are all hand in gloves. They will immediately take forcible possession. You can see what is this apprehension. Then that is
observed that you filed the application, that will be revived.
The interim order was an order of status quo.
Status quo. That was there.
And status quo has changed, Mr. Mohanty. Don't you understand that is for your benefit of observing?
No, status quo on the field, no change.
Status quo after the allotment has been made in their favor. You have to bring all these things now.
My lord, this allotment is also in violation of the status quo order. So, your lordship may that order will be
I understood from Ms. Mahapatra's submission, I am telling you that in between time they have done it. Not when this in appeal interim order was.
No. Before the interim order was passed, there was.
Right. So there is a gap of time and that has been passed. You check up.
Yes,
status quo will not support you. Status quo as on today will mean that the room has been allotted to them.
My lord, we will file the application until then the interim order will continue.
No. Okay.
My lord, another prayer melody, lordship may direct that matter may be placed before the assigned bench.
It is obvious.
If your lordship will not direct.
Is it happening that some order is remitted, the matter is not being listed, it will be immediately listed. All right.
But we can't compel the bench to hear the matter.
No. See,
Item 60. That will be done by Mr. Manathi. Because he needs an interim order right now. All right, you do it. I have observed it. Because otherwise it's stale order. We can do through the stale order to be survived. We have not reflected that he says the room has been already allotted.
And allotment is on pen and paper, my lord. So
this is the change of status quo.
Yes, my lord.
Being a very seasoned civil lawyer, we are all told that he is a seasoned civil lawyer.
No, my lord.
The change in the status quo will mean the entire thing has changed.
But that the status quo order was very much there during pendency of the once the petition was dismissed in this manner, and thereafter they clandestinely issued a letter.
Whatever clandestinely, hand in glove, whatever you say, but that has happened. Earlier status quo has changed. Okay. Next matter.
Item number 66.
May I please your lordship? I mean virtual your lordship may permit me. I am for the intervener applicant. We are the farmers who have suffered a lot because of the elephant movement. We are the farmers who have suffered a lot because of elephant movement.
That's item 66, yeah, if I may.
Yes.
With your permission.
Lordship,
This is a PI. This is a PIL, my lords.
Yes.
My lords, this court was in a way, my lords, monitoring the conservation of elephants, in specifically elephants in the state of Orissa. And this PIL was filed in the wake of certain deaths, elephant deaths, which had happened for various reasons. Now, my lords,
Mr. Manathi, have you visited the elephant tracks in Orissa?
My lords, I have not visited personally, but I have got instruction from the field because there was a joint task force which was constituted, and the joint task force has done some work which my lords have 66.
Oh. Yes.
Which my lords we have placed before this honorable court. Pursuant to my lords this honorable court's orders, a comprehensive action plan was formulated in the month of January. That action plan has been approved in the month of February, and as on date, my lords, it's been 6 months and the action plan is under implementation. So there are various, there were about 10 heads under which the action plan was set up, my lords, which includes, my lords, protection of elephants, which includes, my lords, steps taken for preservation of their habitat, elephant corridors, also the issue, and also another issue of human-animal conflict, which is also another issue, because the issue here is that there are two competing interests, my lords. There are human lives at stake and as well as elephant lives. So there has to be a delicate balance which has to be maintained, and that is also, my lords, part of the comprehensive action plan.
Just please hear you in detail. You just take your seat. First, I hear the counsel for the petitioners.
Please,
because you have served the copies of your policy.
Please, the policy was served back in our affidavit in the month
Any
of
affidavit of the policy stipulations?
Please, minutes with the policy, with the entire policy document. That
whether the petitioners have filed an affidavit on the policy.
On the policy, my lords, directly in reply to that policy, there are no affidavits which have been filed.
All right. That is why I am interjecting in the petitioners. Yes. Yes, Mr. Biswal.
This is a case where the elephants movement in particularly in Khordha, Noyagad and Ganjam border, that is the main concern of the farmers, those who are the intervener applicant in this case, Lordship.
Yes.
What has happened 15 years before, all these elephants, they are confining themselves in Chanka forest range areas, Lordship. Everybody aware of that Chanka area was the area where the elephants they used to confine to this area. But what happened after the industrial activities in the Chanka belt, all these around 20 elephants, they have migrated to the nearby areas that is bordering to Khordha, Noyagad and Ganjam border. More particularly, the areas are three forest range areas that is under the DFO Khordha Lordship. That is at Barbara, Jammugonda one forest range, and Sirikuti. All these are the eco-sensitive area Lordship. All these 20 elephants nowadays they have migrated to those areas, and there is a minor irrigation project that's called the Ronda Dam that is bordering to both Nayagad and Khordha. In that Ronda Dam area, all these elephants are getting good water and also getting their main food is the bamboo leaves Lordship. Just like our main food is rice, their main food is bamboo leaf, where they are getting plentifully, and they are getting plentifully the food and also the water from the Ronda Dam, and they are confining to particularly to that area Lordship. Normally, the elephant is a nomadic animal Lordship. They used to travel in a night around 30 kilometers. But why they are confining to that area? Because of the availability of food and also sufficient water. And all these areas covered by mountains from three corners. Only one side there is the area where path where the vehicles can enter into those areas Lordship. So what we have proposed to the PCCF Principal Chief Conservator Forest and also the PCCF Wildlife to dig a trench so that the elephant, those who are there in the mountains and that MIP areas, minor irrigation project areas, they will not enter into the areas where there is the human habitat and also the cultivable lands, where particularly we the farmers are suffering a lot. For that reason, Lordship, we have proposed 10 proposal before the first meeting which has been held under the able leadership of the Chief Secretary. That is on 6th July 23, Lordship. That is at Secretariat. That the State Wildlife Headquarters, they have issued the notices. In this meeting, Lordship, the Learned Chief Secretary and around this Secretary of Energy, then Revenue Secretary, Forest Secretary, the DG of Police were there also, and the Joint Task Force officials were there. In that first consultative meet, Lordship, we have proposed around 5 main proposal, Lordship. The first proposal was that the elephants where their movement is their maximum, that area is not to be consumed by the excess exploitation should not be there. Like
Mr. Biswal, I have a question. All these concerns have been taken care in the policy regarding the elephants. Whether you find the policy is inadequate, insufficient, or not appropriate for the conservation of the elephants?
Lordship, the policy is welcome which has been initiated by the government of Orissa, but practically things are that because there is a mismatch in between the theory and practice, that is the main problem, Lordship, in those particularly Nayagad, Khordha and Ganjam belt, Lordship. They have mentioned that we are giving matching grant to the farmers, those who are sufficiently, those who have been having their crop loss, Lordship. But question is that this is a very cumbersome job because nowadays they have developed this online compensation claim. No farmers are aware of this fact, Lordship. Earlier they have their...
That is beyond the scope of this public interest litigation. That may be the another subject matter of another public interest litigation. Whether the compensation is going to the proper hand or not, these are not part of this. You just only confine yourself to the conservation and the preservation part of it.
In the last consultative meet, in that paragraph 7.
And after the consultative meet, then the policy has come up. If you have find out any adequacy in the policy, that you should indicate.
Lordship, in that consultative meet in paragraph 7, whether I do not know whether the state has submitted that consultative meet papers. I am reading it.
Have you submitted any minutes of the consultative?
Please, all the meetings that have been convened, the minutes are before in the last meeting which was held on 6th of July. That is part of our affidavit which was filed on
We don't have copies of the
14th of July.
I pray by direction given to give the latest status of the elephant death. Because recently, whatever they have, that affidavit is given, that is more than 2 months back. So recently in the July, last July. After July, in the recent, what status of the so for the elephant and poachers concerned, because 2 forest officials they will be inside that Century mallet.
I know.
I want to mention in this WPC number 14706, I am one of the interveners, my lord. My IA number is 10073. Here I am for the Odisha Non-Gazetted Forest Service Association, and I have made a recommendation for the Chief Conservator of Forest to give some special welfare fund and others also on the 5 points are also there, which mentioned in the
This will only expand the scope of the. This will only expand the scope of the.
Going far beyond that is why
This is going beyond the scope of this PIL. That is, he can file a separate petition for that.
Already I have pointed out. Will be confined to the conservation of the preservation part of the forest vis-a-vis elephant and human-elephant conflict. These 3 broader aspects will be considering.
Please,
But Ms. Pagi was saying that you have not supplied the copies of these affidavits to her.
July meeting you have.
Will sir. They should give a latest mallet status also.
In 1 month, nothing substantial changes in this perspective.
Because every day new things are taking place, mallet.
Therefore,
their monitoring group is there. If you want information, of course, you can ask.
Because this comprehensive action plan, which has been put in place, it is not only government servants who are part of it. We have included some of the best experts from all over the country who have been working in this field specifically, and who have in fact on previous occasions also addressed this honorable court. And in fact, Milads, the CCF, who's the convener of the JTF, he's also online, Milads. If my lords permits or if my lords has any clarification, my lords, he would be there to assist, my lords. Mr. Manoj Nair, Dr. Manoj Nair, he's also there online, my lords.
I would like to add, my lord, beside all these things, my lord, till date, the elephant death has not been checked, my lord. The conflict is there, my lord. Even an elephant conflict is going on, my lord. Like in single call, my lord. The situation is something aggravated, and no such type of actions, my lord, which can be visualized, my lord. Since last 1 year, this PIL is going on, my lord, but no such step has been taken, my lord.
Well, as far as the elephant deaths are concerned, my instructions are since the last 1 year, my lords, from 2023 till 29th of August, my lords, 29th of August as in today, my lords, there has been 24 elephant deaths, my lords. And out of these 24 deaths, my lords, we have done, regarding the cause, my lords, there have been 4 deaths due to electrocution, 7 deaths due to diseases, 2 natural deaths, 1 lightning, 1 trampling, 1 infighting, 4 train accident, and 4 deaths, my lords, of which reasons are not known. When we compare it with
how many deaths occurred from the train accident?
4 minutes. 4 minutes.
The number is very high, Mr.
Please,
in comparison to the elephant population in the state of Orissa. So, have you identified this Tuscus track vis-a-vis the railway track?
Please, that is also one of the issues that we are tackling in our action plan as to how to create millers. Because at some places, millers, where there is railway track or where the elephant crossing, because
I believe that in both there is a one issue, and the Simlipal. Simlipal, in the downgrading there is a railway track.
There is a railway track.
And my lord, the purpose of this Joint Task Force Act, that is totally failed, my lord. It was a constituted, my lord, to control the elephant death, my lord. But till that, my lord, no such type of things has been done, my lord, which can be visualized and which can be checked, my lord.
Where is Mr. Manoj Mishra?
Manoj Nair. Dr. Nair can join.
Dr. Rai is here.
Dr. Manoj Nair. So online person,
we are on. That's it.
Your Lordship, I'm humbled to be in your presence, sir. We have been closely monitoring, as our counsel, Mr. Kishore Mandi had mentioned. Ishwar Mandi had mentioned. We've been closely following this entire implementation of the comprehensive action plan. And Your Honor, as was mentioned, this has been put together with a great deal of thought and enormous effort involving who's who of elephant conservation in the country, Your Honor, actually. As Your Honor, and you can very well appreciate it.
Mr. Naik, there are several questions actually coming up very scatteredly. Suppose the death of the elephants and 4 deaths with the railway accident. This is a real cause of concern. And 2 deaths are completely for unknown reason. What is the reason? Nobody can say that. So if I propose that on 4th of this month, next month, September, if you come to the High Court, and I will also request all the lawyers, you give a presentation before that, because there is a doubt that your joint task force has completely failed, how you are working to implement the policy and for the protection. Is it possible on 4th at, suppose at 4:30 you come in the High Court?
Yes, Your Honor.
Or otherwise, if you are feeling inconvenient on a particular date, you can also propose a new date.
No, Your Honor, it's fine. Your Honor, because I report to the Chief Conservator, Principal Chief Conservator of Forest Wildlife, Your Honor, I can always come back very quickly, as soon as possible. I'll get back through our counsel, Your Honor, if you kindly permit.
Yes.
Because very quickly, as soon as possible, we'll be more than happy to give a detailed presentation of what we have done so far. What
I want that you do a PPT presentation to them, so that they can also avoid themselves what you are actually doing.
Absolutely.
Well, beside I propose, my lord, with the petitioners, with the counsel for the petitioner, we may be added with the JTF, my lord. Yes, that because what rejected by
lawyer side.
I propose, my lord.
First of all, you have to give the presentation. They have totally failed. Try to understand them what is happening, because none of the councillors within the real tracks near habitat of the elephant. So all are on the basis of the secondary information you are making submission before the court. So those who have the primary information, that will be reliable by the court for obvious reason. So that is why I am just facilitating a conversation between the persons who are really in the field and you, so that you can put number of questions to them for clear doubt or no more, whatever. That will be organized in the High Court premises. Yes, madam. I have proposed, if you can confirm, if you cannot confirm it, Mr. Nayak, you can.
Your Honor, Your Honor, may I please come in?
My lord, we will provide the date after discussion. We will provide the date tomorrow.
Your Lordship, intervener number.
Yes, within half an hour, please. Dr. Nair, you please consult with, then within half an hour, please come back.
Lordship, 4th September, Your Lordship is putting the date, Lordship.
Wait. Honorable Court is asking him for.
4th is okay for you.
Your Honor, with your kind permission, Your Honor, will we be able to take 10 days, Your Honor, to come out with the entire presentation?
All right. Definitely 10 days. So we are making it 11th of September.
11th of September.
11th September.
Yes, Your Honor. Noted, Your Honor.
Your Lordship, this is item number 66 and intervention application number 640 of 2023 in the same Geeta Raut case. I may be allowed to put forward my point.
Whom you are representing by intervention?
Save Elephant Foundation Trust. Save Elephant Foundation Trust in the intervention application number 640 of 2023. Your Lordship, the comprehensive action plan that is stated here is actually failed to justify the ex gratia amount in the name of compassion payment. And what we are seeking is, we are seeking a sustainable mitigating measure, that is compensation. So in the next presentation, we are also expecting a reply from the JTF that why ex gratia is still continued as a sustainable solution.
Lordship, in this matter,
this specific IA 640 millage, we have filed a reply. So if my learned friend can give a reply to a rejoinder to a reply, we would be in a better position, my lords, to address this honorable court. Because we have filed a comprehensive reply.
In which case?
My lords, this is IS 640 of 2023. This is WPC 14706, the lead matter, Geeta Raut versus State of Odisha.
Just find out.
We have not supplied with any.
Please, how can we supply to you?
We have already given our email ID and there is no reply, there is no response we have received.
Any order in the past of this intervention application? Any idea?
Please, my lords. Yes.
9.5.
Lordship, in the last sub-item.
One by one.
We are looking into the 9 May order.
It's 9. It's 9.
Who is appearing for the WSO?
Mr. Pani, Society for Wildlife. Mr. Pani.
Mr. Pani, he is online. He's online.
Mr. Pani?
Yes, Mr. Pani, he's online.
Yes, Mr. Pani.
Lordship, I am appearing for the last sub-item. It's 14057 of 2023. Here is the order of Honorable National Green Tribunal, which has been finalized way back in 2021, 17th August 2021, was the final order of NGT. And that was stayed with the before this Honorable Tribunal, showing that this is a parallel proceeding. In fact, the present proceeding which was ongoing before the NGT is a execution application. So execution application proceeding is pursuant to the non-compliance of the order dated 17/8/2021. My humble submission before your lordship is that, so for the matter before Honorable NGT is concerned, and so for the present proceeding ongoing before your lordship is concerned, both are absolutely different. Their prayers is different, everything is different. And so for the jurisdiction part is concerned, in case they are agreed with the order of Honorable NGT, they must have and they could have appealed under Section 22 of NGT Act before Supreme Court. That has never been done. So in a execution proceeding, when the court has taken...
Well, what is the date of this interim order by staying the proceeding? Can you just refer?
Yes, Lordship, it is 4th May 2023, your Lordship's order.
And your this 4th May order. So, 4th May, there is no order. It's the last order is the 9th May, 2023.
That is that.
Lordship's order is a 4th May 2023. That is
the... if I may assist. In the
fact, that is the order wherein your Lordship has stayed the proceeding before NGT. And that is how I have challenged. I made an application for recall of the order. Write my IA number 6983 of 2020.
One moment, Mr. Pani, please wait. Last petition, first order. Yesterday somebody argued we had a decision over the NGT.
No, it's 4753.
14057. 14057 of 2023.
Item 66.
No, same item last. Sub item. Item 66, yes, last one. State of Orissa versus Wildlife Society. Order of NBC has been stayed.
Just to assist your lordship, on 4th, the order of stay was passed, and on 9, they wanted to vacate it, and there is some discussion as to why it should not be vacated at that stage.
Okay, what is the reason behind?
Well, let's me see the 9th May order from para 11 onwards. That is para 11. The heading is IA 6983 of 2023 arising out of WPC 14057, in which Mr. Pani appears.
No, it says the parallel proceeding both in the NGT and this court on the same issue is not desirable. According to Mr. Pani, this is not the same issue.
No, Millards, in fact, this is what was, because they had filed an IA for vacation of paragraph. Whereas I'm referring to paragraph 11 of the order passed on 9th of May in the Geeta Raut batch of matters 14076.
This is a common order everywhere.
Yes, one common order. That is para 11. Para 11. WSO, it starts, WSO has filed this IA seeking vacation of the aforesaid stay order dated 4th May 2023. Millards has it?
Yes, the order was to enforce that elephant corridor. So that order has been stayed.
That order has been stayed, which was before the NGT. Thereafter, Millards, here after the state appealed, and after Millards, the stay was obtained.
Yeah, but why did you appeal?
Millards, because
it was not possible within that time.
No, Millards, what has happened is before the NGT, there were 14 elephant corridors which were identified at a particular point of time. Now, Millards, after this comprehensive action plan has come, what has happened is there are about 3-4 organizations who have come up with different elephant corridors. So as per the experts and as per the JTF, Millards, there has to be a process called ground truthing, in which, Millards, there are 2 seasons. There's a dry season and there's a wet season. And so they want to ascertain the path that the elephants are taking in both the seasons. And that will take about a year or 2 years. That is, Millards, the timeline that is set. And only after that ground truthing work exercise has been undertaken, will we be in a position to put in these elephant corridors as on 2023, Millards. And this is, Millards, something that is being actively pursued by the JTF and in the action plan. Therefore, Millards, it was submitted that if that those 14 elephant corridors, on which, Millards, the experts have also said that some of those 14 are also not feasible, and it will be a waste to sort of notify those 14, some of those 14. So therefore, Millards, it was the considered view of this honorable court on 9th May that at this point in time, it's not desirable to vacate that stay because this process is going on. This identification of elephant corridors, that is going on. That is, Millards, the long and short.
Lordship, that is not the reason. In fact, so far the order is concerned, it clearly says that since they have not filed the reply to my IA, that's why that was a preliminary view. And now they have taken that, they have already filed the reply. So the whole issue before your Lordship, whether it is a parallel proceeding 1, and so far my submission is concerned, since the order has been obtained fraudulently, in fact, your Lordship has been given an impression that there is a parallel proceeding 1, and secondly, another impression was given that the orders of this honorable court has been placed before NGT, and despite
Have you filed the reply, Mr. Monti?
Please, the reply has been filed. We have filed.
All right. On 11th, we will take up this issue separately. Right?
Yes, Lordship. This may be detagged, Lordship. This, yes.
This issue will take up separately, vacation issue, because otherwise there is some legal implication also.
Lordship, I have only one submission, Lordship, with the Lordship's permission. On the 11th September, Lordship, what I pray, we the farmers are suffering because of the state action inaction. What we pray, let the joint task force file an affidavit to the effect that how many hectares of land they have given this forest land for non-forest purpose, because the forest land is becoming squeezed day by day.
That is a completely a separate issue. You have to deal with the issue separately.
This is a separate.
If you want to file a public interest litigation, don't bring everything under the forest, because these issues is that read a multidisciplinary this approach, and that may not be proper, because we'll be losing that focus now.
No, it is the forest land which has been used for non-forest purpose. That is why the land becoming squeezed. Let's see.
Always you file in specific instances, then will pass the order. You file an application.
Let's see.
Yes.
My lords, I have a few suggestions, my lords. Here, in fact, in this batch, there are various competing interests from various regions. Like, first one is vis-a-vis a particular issue. Then there are like if my lord takes up the matter by Mrs. Mrinalini Padhi, she is for the man-animal conflict part. Hers is vis-a-vis a particular district, Angul. Then I am a
reason, Mr. Minister, what I propose, let them explain how they are operating with this policy they have taken.
So what I was submitting is, if my lord may consider either appointing a nodal counsel or an amicus, so that my lord gets an overview of the entire set of cases. Otherwise, my lord, as my lord sees, there would be submissions from varied areas. Like there's one issue vis-a-vis the electricity companies, where these elephants get hit and then there is electrocution. Those have been included. That's an issue which would emerge in the course of submissions. Then there's an issue of inaction vis-a-vis filing of charge sheets, which the state, there is some dealing in that. That was being taken up on an urgent basis by the court. The court was monitoring the filing of charge sheets vis-a-vis those debts. So that is something which I think the state has to come up with. So it's just a suggestion. My lord may consider it maybe on the next date. But otherwise,
trying to actually pass the order on the every point, not in a, this is a common order, is creating a lot of difficulty for us to also. So on 11th, I think this let the interaction take place. Everybody can openly discuss the issues as relating to the policy and implementation in the field level. What is happening there? So that way you just organize, we can facilitate that our video conferencing room, that you can sit there and also can see what the presentation is all about.
In presence of all the councils.
All the councils and the interveners also.
Yes,
everybody can take part.
They may consider filing an up-to-date status report vis-a-vis the criminal investigations.
Okay.
That is something the state will not object to that. That is
in JTF also the additional SP is a member. In fact, it has been filed. In fact, on each before each hearing, my lords, 2 affidavits are filed. One is filed by Dr. Nair, my lords, and one is filed by the additional SP who oversees these investigations. So in fact, that also is being monitored. So we will file another affidavit before 11th of September. And my lords, another issue I wanted to highlight, my lords, is that in all the affidavits, we have also given, because we have kept some timelines for each and every aspect. So it's not an umbrella issue. We have given granular details, and then in those, my lords, we have given specific timelines. So in every affidavit, my lords, we give the implementation vis-a-vis each subheading under that 10 major heads. So, my lords, that is also something that is before this honorable court. So, my lords, to say that nothing is happening is, my lords, in my humble submission, is an insincere argument to say the least, my lords. So in any case, my lords, on 11th, my lords,
we have not exchange the information.
Please, my lords.
What is going to happen? That is why I say the interact present what you
please. That is the best.
They are unable to control my lord. That is my submission. I have not said that nothing is happening. I submit that that has not been controlled.
What is not being controlled?
That is elephant death, my lord, and this conflict also. But measures, as they're in their policies, my lord, the measures have not taken on the ground, my lord. It's only pen and paper. Well, the time must be fixed, my lord, 11th at 4:30.
4:30 is.
Interaction 4:30 minutes.
Lordship, the WPC number 14057 of 2023, the Wildlife Society of Odisha NGT
They'll be
matter,
dealing.
that may be removed from this list.
That will not be delayed. Why it will not be dealing? Because, well, as I explained,
No, it will be taking out this matter separately because they are.
but let it be with this batch.
That's this heard Mr. Shankar Prasad Pani, Learned Council. It is in WPC number 14057 of
Is for the
2023.
opposite party.
Who is representing the
Wildlife Society.
Wildlife Society of Orissa, WSO. By, in that writ petition, one interlocutory application has been filed seeking vacation of the stay order dated 4th May 2023. So, Mr. I. Mohanty, Council, E. Mohanty, or I, you right?
Ishwar Mohanty, I.
Mohanty, Learned Regional Standing Council, has stated the proceeding that the state has filed their response to the said application seeking vacation. Stop. Mr. Pani, Learned Council has not asked for any accommodation for filing any rejoinder to the response filed by the state. To list this application being IA number 6983 of 2023 on 11/9/2029 for consideration on the prayer of the vacation of the order dated 4th May 2023 on merit. All this vacation is stopped. In generally, in all the matters, let the matter be listed on 11th September 2023. It has been agreed upon by the council for the parties that the Mr. Dr. Manoj Kumar Naik. What is Dr. Naik's?
Nair. Dr. Manoj B. Nair.
Manoj B. Nair. Is the operation head of this?
Yes, along with his team, they will come.
Now, what is his official designation?
He's CCF Wildlife.
Chief Conservator.
Chief Conservator of Forest within bracket Wildlife would make a presentation on ground reality of the. There's a problem this public interest litigation is dealing on, and also how the have you given any name to the policy?
Please, this is the comprehensive action plan.
Comprehensive action. Also, how the comprehensive action plan for elephant conservation.
No, sir.
Human wildlife conflict.
Wild. It's comprehensive action plan for conservation of elephants and mitigation of human-elephant conflict in Odisha.
Let's give it.
Please, Miles will find it at annexure Y1 of our affidavit, which was filed on. Well, it's 10th of March 2023.
First writ petition.
Please, minutes. First writ petition.
Stop. This court would request all the council appearing for the parties, including the interveners, to be present at 4:30 at the High Court of Orissa's VC room in the second floor of the new court building on the day. Stop. I would request Dr. Nair to, for initiating the conversation, No, the screen is not there. Because considering the crowd, so the new old conference hall.
This will be a small room. That's what we are discussing.
New conference hall in the old building.
Yes.
All right. We request Dr. Nair to initiate the conversation by PPT so that everybody can get the claims of the problem at the beginning. And we believe that will streamline the conversation to a definite direction in order to find the solutions to the problem. All right?
Yes.
Only this other, the vacation matter we'll hear on 11th, another is the presentation. Right.
Lordship may fix it at 2 p.m. At 2 p.m. it may be listed on 11th so that.
All right, make it on 11, 2 p.m. It should be from on order. Actually, that way it will be passed. And Mr. Meshwar, that you are appointing a nodal council will consider.
Just for the convenience of the court.
No.
And it's not. Because there are certain directions vis-a-vis those distribution companies which have to be probably followed up. I think the state may agree with me.
You also filed an affidavit.
We'll file an affidavit.
The distribution companies have also, they are represented by a council.
Companies are represented.
We have filed our respective affidavits. There are 4 discoms, the Western, South, North, and Central. They have filed our respective affidavits because we have been implicated in one of the writs. So we filed in those writs, that is on record.
So there are occasions where the JTF also wants directions vis-a-vis some of these entities. So a nodal council may.
You are representing JTF?
No, I'm actually for one of the petitioners.
Who is that?
No, I represent the JTF. The JTF is a. The JTF in all its meetings also invites the CEOs of the discoms, the 4 discoms. So they are also represented in the meetings.
Make it a part of this conversation on the day to face. Okay? Make it a separate area.
Please.
So that no confusion is there. Please. You can find a direction out of this conversation.
Please.
Yes,
that's better. Item number 67. But in item 66, wrong matter has been wrongly tagged with the election matter regulation for SC OBC minute, which second item from the bottom. WPC number 4571 of 22.
That is wrongly tagged.
Wrongly tagged.
It has to be delisted.
WPC number?
4571 of 2022.
So this matter was wrong.
So what a wrong number
If this repetition and its batch, that should be detailed. The matter will be listed on 11 September 2023 separately.
What is the correct number? Because there must be some other case. 4571 is mentioned in that order. It must be something else.
Yes, call the other matter.
Item number 67.
457.
457. Right, please,
That's one major.
Yes, Mr. Panig.
Annex 8, page 55 is the import order passed with the Honorable Civil Judge Millard, where a direction has been given to regularize the unauthorized construction, which was not bona fide, and at any stretch of imagination, it cannot be regularized. Therefore, the authorities before my lords Millard, when the order was passed of the Millard, taking into consideration the concession stated to have been given by the council before the respondent number 1 authority Millard. Case 57 will also kindly see. Now, as per the scheme, it cannot be regularized, and also it doesn't meet the fire safety point of view. I will also include the scheme Therefore, the authority has no objection to regulate the construction if they meet the specification of the scheme. But they,
who's appealing for the authority? Who's appealing for the authority? So you are appealing for the authority.
You can see the order, page 57, is paragraph 3, the quoted portion where the petitioner submitted application for regulation of the structure under Sarvakshama Yojana. The advocate for the BDA, Barampur, submitted that provision for parking space has been made and thus the illegal structure can be regularized under the Sarvakshama scheme. Taking into consideration this concession stated to have been given by the council appealing for the development authority, this order was passed. Paragraph 4, the direct ordering portion.
Yes.
It is at this stage, Mr. Panigal, the council for the Barampur Development Authority submits. Once such regulation is made, same may create a precedent in other regulations. Keeping in this in view, this court, while finding that there has been already concession by the council for the development authority for no impediment in considering the case of the petitioner under the Sarvakshama scheme, while keeping in view the private appealing parties have already made a provision for parking space, this court here, taking into consideration the statement of Mr. Panigal and the council that this parking space made available by the appealing parties is by way of rent and not the permanent parking space available to the commercial utilization involved may create problem in future. Well, a parking space was taken on rent to regulate the construction, but although the regulation is to be made permanently, it's a permanent construction. Once the regulation is made,
the parking lot was not part of the design.
No.
How have you approved the design?
Well, the ground floor was in the design layout. The ground floor was specified for the parking lot, but they have not laid the ground floor for parking lot.
What they have done there?
They have constructed the building exceeding their land also. Encroaching upon the government land, encroaching upon the side land which
have you issued the completion certificate according to the new act, RERA?
No. That this construction was made prior to that period.
In which year?
Well,
when the old construction will come under the purview of RERA.
Yes.
So that is a question whether have you issued the completion certificate of the construction?
Well, this construction was objected when they deviated the plan.
Authority objected or some other?
Authority objected. Authority objected and unauthorized case was also initiated and thereafter the building was sealed.
Okay.
And direction was made because you know, she kindly see, let me place the dead chart for the convenience. Well, I'm coming to page 2. May place it is 3 pages. 29/4/2009. The respondent number 2 and 3 being the owners of plot number 278-1088 and plot number 275-1087 under Khata number 89-124 of Satyanarayanpur Mauza Barampur of an area 159.60 square meters applied for approval of building plan for construction of B plus 3-story commercial residential building. 19/5/2009, the appellate authority by letter number 1281 granted permission for construction over 88.32 square meters. Out of 159.60 square meters, permission was granted for 88.32 square meters out of the total area of 159.60 square meters, and the basement was reserved for parking.
Yes.
The respondent, instead of constructing the B plus 3-story building over the permitted area of 88.32 square meters, started construction of B plus 4-story building covering 166.70 square meters, which is excess of their plots. that is in excess of the plot area encroaching upon the adjacent British land, 10 feet 6 feet 6 inch into 10 feet 6 inch on northern side, and the public domain 36 feet 6 inch and 5 feet on the southern side, that is 104% deviation of the building plan. Then in 2011, therefore, the unauthorized construction case 15 of 2011 was initiated as against the respondent number 2 and 3, and notice of show cause was issued with notice to stop construction. But they did not stop construction, but the respondents, instead of stopping construction and filing show cause, approached this code in WPC number 7963 of 2012.
Yes.
Next, we are on 5.
The past in the WPC.
There the order was passed to file the show cause in response to the notice of show cause and to submit a revised building plan.
Yes.
Next date period 5/10/2012.
To a learned council. If this earlier repetition, they were permitted to file the revised building plan.
Yes.
At that time, you have not challenged that order.
No, they submitted it.
Now contend that there is no scope of the revising the plan after the approved plan has been deviated. You would have should have challenged that order.
Because we have to consider whether that comes under the purview of the or not. Because once they started the unauthorized construction, they get in the building plan.
That means the copy of this is available in the writ petition, present writ petition.
That order is not available.
Not available?
No letter.
Can you produce the?
But I have mentioned at the bottom portion, page 2, WPC number 7963 of 2012. That was disposed of on page 3. I have mentioned 5/10/2012. That was disposed of. 5/10/2012. Writ petition is disposed of with a direction to file reply to the show cause notice with revised building plan for consideration of the appellate authority.
What was the consideration?
Well, that was rejected, because I have mentioned that
order to file the writ petition, present writ petition.
No, they did not challenge that. They did not challenge that. They
filed an appeal.
They filed an appeal against the final order of the unauthorized construction case where direction was made for demolition.
Okay.
But the rejection of the plan, they did not challenge that.
All right.
Page 3, 5/10/2012, that petition was disposed of with a direction to file reply to the show cause notice with revised plan for consideration of the appellate authority. The respondent filed the show cause and revised plan. 28/7/2015, the planning member considered the revised plan, rejected the same since the unauthorized construction was not compoundable. That was the letter at Annex 1, page 16.
Okay.
Next, 26/7/2017, final order was passed on the unauthorized construction case number 15 of 2011 for sealing of the building, and notice was issued to remove the articles from the building. As by that time, the respondent had leased out the entire building for opening up a commercial shop, Motherstyle Retail Private Limited. Then we learned 11/8/2017, after giving 15 days time, the building was sealed and the key was given of the manager of that shop. The respondent again approached the appellate authority for desealing of the building for clearing of goods and articles. Again, 15 days time was allowed. On 11/1/2019, 15 days time was allowed by the collector and vice chairman for the said purpose. The respondent did not cooperate the authorities. Then on 7/2/2018, the respondents challenged the seizure in WPC number 2391 of 2018, making a plan to unlock the building. On 23/2018, order of status quo was passed by issuing notice to the present appellants. On 25/7/2019, considering the prayer to unlock the building, this honorable court, while adjourning the case to forum chapter, directed the appellant to open the lock and key for the purpose of allowing the respondent to remove the stocks and thereafter to prove the building under the lock and key again. The respondents did not cooperate for compliance of the order of this honorable court, rather pursued the appeal during OD appeal number 1 of 2018, running parallel challenging the final order dated 26/7/2017 passed in the unauthorized case number 15/2011. On 1/8/2019, the respondent cunningly withdrew the petition because there is a direction to cooperate for desealing the building and remove the activities. Thereafter, it was to be sealed. They did not cooperate with the application. Within the application, we produced the order of the event in the said appeal for the purpose of passing of the final order without disclosing the order dated 25/7/2019 passed in the petition facilitating in the unlock. On 7/8/2019, the OD appeal number 1 of 2018 was allowed with a direction to consider evaluation of the building under SUBHASIS scheme. That order is at Annexure 6 below. And the scheme I have also enclosed at Annexure 7. Present appellant challenged the order passed, the authority, the development authority challenged that order passed in appeal case number 1 of 2018 before this court in WPC number 7370/2020. On 28/2/2023, the Honorable Single Judge giving much emphasis on the concession stated to have been given by the Council appearing for the in the OD appeal, directing for regulation of the illegal construction, which is beyond the purview of the SUBHASIS scheme. Then implementation Annexure 8.
Yes.
But my submission that the illegal construction will be respected to 3. Having been within the permissible limit under the scheme, cannot be engaged without making some alteration to the building to bring the same into purview of regulation. And therefore, the applicant development authority is concerned to assume the order on the receipt grounds. Now, well, your lordship kindly will come to the scheme, Miller. Annexure 7, page 37 is the scheme.
Annexure 7.
Page 37 of the appeal.
The order passed in that writ petition filed by Bazaar Retail.
That was withdrawn, Miller.
That was withdrawn.
Yes, the second writ petition was withdrawn.
Okay.
Here, interestingly, the owners of the land filed the appeal. And the shop which was running the lease basis, he filed a writ petition.
So they wanted to empty the shop that is.
They had already confusion in the matters. We'll also currently see page 37 the scheme. But page 38 plus 3 is the applicability.
Yes.
But clause 3(2) says that the scheme is applicable only to such unauthorized constructions that are structurally safe and do not affect any public interest or safety or interfere with any public activity. Here, Miller, now we should come to page 42, Miller. What is the relaxation of planning and building norms while considering the application for regulation of the unauthorized construction? Clause 6, Miller, but the relevant portion is at page 45.
Yes.
The explanation. Irrespective of the relaxation provided in this para, the accessibility of fire engine and firefighting personnel to different sites and parts of special buildings shall be assessed by the state fire service organization while issuing no objection certificate or fire safety certificate. The owner shall provide all the fire prevention and fire safety installations as per the provisions of National Building Code of India and its additional fire protection measures as recommended by the State Fire Service Organization, the region of which shall be recorded in writing. Here, it is a thickly populated area. In Barampur, it is a thickly populated area. There is no setback. But for accessibility of the fire safety engine and fire personnel, because it is a commercial, it is used for a commercial purpose.
Yes. It is actually for a hybrid purpose.
Yes.
Commercial plus residential purpose.
The plan is approved for residential for commercial purpose, but the utility is entirely for commercial purpose. But That will also be kindly see the order of the honorable single judge. That there is no parking space, but an agreement of executed with the adjacent landowner for parking space, and the order is 58, paragraph 5.
Yes.
The appending portion of the order. It is in view of the matter, this court while declining to interpret in the order of the appellate authority for clear concession of the development authority involved. Only the concession, even if there is no written concession, even if the council has given a concession beyond or contrary to the statutory provision of the guideline, but that is not binding upon the authority solution, my lord. Authority involved, however, observes the regulation of the illegal construction dependent on the direction of the appellate authority will be approved by the development authority the commitment before the appellate authority. The development petitioner files some agreement between the owner of the parking space and himself, undertaking to include the parking space for so long as the commercial institution continues.
Was the parking the only deviation?
No, parking is the deviation.
No, about this fire safety and all that you.
Yes.
All that?
That is nothing there.
That is nothing there means what?
They have constructed the building in excess to their land, encroaching upon the adjacent land, the government land. The adjacent land belongs to the building. They subsequently stated that they have purchased that land, but they have not applied for approval of the plan on that land, along with their own land.
They have constructed there on that land.
Yes, that is the obligation of the authority.
So this order of this removal beyond what is they have constructed illegality. What happened to that order? What happened to that order? It is stayed by this court.
No, that was not stayed. But after filing of the that rate application, that was taken into consideration and disposed of.
Because that order you said had not gone, they challenged it before the appellate authority.
Yes.
So writ petition, only some interim orders were passed that you open the
since they challenged the matter in the appellate authority.
Yes.
Therefore, the eviction order was not executed.
But what is the order is of the appellate authority? Because that was against the final order.
Yes.
Yes. So what was that?
The order of the appellate authority was to consider for regulation, consider the unauthorized construction for regulation, and the direction was made to them to remove the construction made over the public land. That was Millard.
That they have not challenged, you have challenged that.
Yes, because I challenged that Millard. Because
no, just a minute.
It cannot be regularized.
Show us the order of the appellate authority.
Millard.
Annexure 6, page 2.
Annexure 6, page 29.
Ordering portion started page 33 also.
No, prior to that, Millard, the deviation has been reduced at the submission portion at the first page, Millard, page 29. One deviation they made. Then Millard, you also kindly come to the operating portion, Millard.
Oh. Did they remove the encroachment on the public land?
Yes, sir, Rathi.
But they only removed the slabs which were made on the public drain.
Because that was the construction of the public drain.
Yes.
That they have complied.
No,
other unauthorized structures, because it says remove the encroachment on the public land as well as other unauthorized structures. ଆଉ ନଥିଲା କିଛି
Other unauthorized structures.
What is the order of the application?
Here.
Apply to 29 and 6 million.
They have telling the father.
Many conventional.
Then just a minute, let me complete first.
Seven-page order, but ultimately.
Page 33. Page 33 is the first paragraph, before the ordering portion, that was the last hearing on 23/2019, the advocate for the petitioner, those are the present respondents, as well as the advocate for the BDA, Barampur was present. The planning member BDA Barampur was also present. The planning member BDA Barampur submitted that if any construction is not regularized in previous order, it can be regularized under Sarvakema Yojana scheme if the building is within the FAR, floor area ratio. Because they have made construction beyond the floor area ratio allowed to them. But in the instant case, as the applicant has encroached 23.32 square meters of government land, it can be regularized. It is seen from the PW submitted by the BDA Barampur that the petitioner has encroached an extent of so-and-so of temple land towards northern side of his plot and an extent of so-and-so land over the dam from western side of the plot. The advocate for the petitioner submitted that in this case, the land of the deity has been reconciled with the temple land. No government land has been encroached. It appears from the photograph of the shoe plot submitted by the party that one P.D. Sujanan Rao has also made his boundary touching the BMC road. The Tahsildar Barampur and the BMC Barampur were asked to find out the portion of the government land enclosed by the petitioner within a week. Thereafter, this order was passed, my lord.
So who is P.V. Suryanarayan Rao?
But he is the managing trustee of the temple.
So if he has made structure touching the government road, that means this person can also be permitted.
That is the
Yes, Mr. Counsel, we find this very difficult to accept the decision of the learned single judge.
LRC.
We have no business to tell the competent authorities to regularize the illegal constructions.
No, the illegal construction is there, LRC. Admittedly, there is some illegal construction. So far as construction is concerned, so for public road, there is only step towards the main road LRC over the drain. And as per the, in compliance to the direction of the appellant authority, that has already been removed. So for the other illegal constructions of towards the DTO LRC, with due permission from the competent authority, that is the endowment commissioner, the managing trustee is that they have leased the property to the present respondent 2 to 3, and they have permitted to utilize the same for the
first of all, part of your original sanction plan.
Yes, that is debated some extent, which is admitted fact LRC.
What?
And that can be regularized LRC.
Under which rule show us the rule?
There is no rule, but as per the
we will not encourage the
as per scheme annexed by me, by the authority LRC, that relaxation is made, which there is no hindrance to the public LRC. In this case, there is no hindrance to the public. So far the fire safety is concerned, everything the present respondent LRC, they are following the fire safety rules LRC. They are applied for the same due to sealing of the building LRC that has not been completed by the authorities.
No, sealing of the building, but that is over since long.
Yes, but just after running the business LRC, the dispute arose.
and the case has been instituted.
This appellate order has been passed in 2019.
Yes, my lordship.
Thereafter, you complied with the fire safety.
No, my lordship. The building is sealed, your lordship.
Still,
for which it is since 17, your lordship.
All right.
Since 2017.
Okay.
For which 80% work has been done, only 20% if the building sealed out, your lordship.
Representation filed by this deviant, this person, here is the, I think, opposition only respondent. He is the only respondent.
Correct.
Yes.
He is the only respondent. So that what step you have taken from 2016? Only seal this building. First of all, the revised plan was rejected.
Yes.
It had its own implications.
Yes.
Implication is that there will be no revision of the plan and section plan will survive.
Manner.
So the other part are all the illegal construction.
Manner.
What you have done so long?
But so far as that illegal construction, they challenge it in appeal. Since the appeal was pending, but therefore the authority did not take any step, and only the building was taken under
appellate authority under that act.
Manner.
Municipal Corporation Act.
That's OD Act.
No, it's the OD Act, Development Authorities Act.
In that,
there is any express provision of regularizing the deviation that is made during the construction.
Yes, that's all.
But in fact, there is no express provision. But after the decision of the Honorable Supreme Court, in the case of French colony, thereafter the government took steps for regulation of the unauthorized construction, where the unauthorized constructions were bona fide and due to some misunderstanding.
You probably had a scheme, some Sarva Khyama scheme.
Yes, Miller.
That must be
Yes. Construction, Sarva Khyama scheme.
Yes.
That is the scheme of the government to the unauthorized constructions, Miller.
Government means there is not part of the statute.
But in exercise of the statutory power, the government has framed that scheme.
That scheme.
Miller, yes, Miller. I have enclosed Annexure 7, Miller, page 37. In exercise of the power on section 124 of the Orissa Development Authorities Act, this scheme was floated by the government. That was a scheme for regulation of unauthorized construction 2019.
Within the framework standards prescribed for fire safety and structural life.
I was placing this scheme to show that the fire safety of the public is necessary.
No, but as you said, if it is kept under lock, how will that be done?
No. Keeping prior to that, Miller, they have started a business establishment there.
Before obtaining fire safety.
When the unauthorized construction case was disposed of, there was a direction to stop construction. They did not comply. They proceeded with the construction. They constructed B plus 1-story building, A plus of B plus 3-story building, and access to their area also. Encouraging the adjacent and government land. This is their intentionally they did this construction.
Now it is the what can be done? The building will be demolished or it will be yes. Yes.
But in number of cases, we are organizing the construction.
So what do you suggest?
It is in a thicky populated area, and it's around the business establishment. The fire safety of the local persons is important.
So what do you want? What is necessary?
So as I place that, Miller, let them bring the building into the FIR area.
FIR area?
That fire ratio they are allowed because the fire engine and fire safety personnel have to reach so that they can reach at the place in case of any untoward incident. Miller. Let them to make the building into the purview of the scheme so that we regularize. We have no objection to regulation.
What about that parking thing? You were objecting about that parking which they rent.
The ground floor is parking.
Have you filed that you will do that?
Because you conceded to that. Again, you are conceding.
Yes, Miller.
Conceding, and they said no, that was on the basis of that it was gone. Now it is one of the grounds of your challenge. You file an affidavit that in the Sarva scheme within that will permit to keep the part of the building by way of regularization.
Yes, Lord. That will also be.
Don't blow hot and cold. You say what you want. So
Yes,
he knows what he has to do.
Yes.
Apply.
Yes. If they make the building into the public Sarva scheme,
State it.
the authority will comply.
Generally, say what all is necessary, then he can complete.
Yes, yes, Lord. Yes.
But again, he will do something. You will say it is not within the scheme. That is
because all the points of the building.
Exactly. So ratio, how will they maintain? If they don't have parking, how will they maintain ratio?
The parking, the ground floor is there. The ground floor is reserved for parking. So we can use the ground. They can use the ground floor for parking and the other two floors they can use for residential and commercial.
The structural construction permits that the entire ground floor can be used for the parking.
Yes, ground floor was reserved for parking. In the plan, the ground floor is reserved for parking, and beside the ground floor, three floors.
Lordship, for a moment, have the glance on page 30, the appellant order, second page, Lordship. So, for the parking is concerned, Lordship.
They are challenging that order. That
Yes, Lordship.
since it's a commercial building, it has to be safe for the public.
Yes, yes. On that score, I am submitting, Lordship. Their challenge is regarding two scope. One is encroachment of public land. So far, the drainage concern, which has already been removed in view of the complaints of order passed by the appellant on the appellant court. So the parking is concerned, Lordship. For a moment, there is page 30. The trustee of the DT, after getting the due permission from the Endowment Commissioner, and placing the Lordship.
No, that you have stated. There is another thing regarding the deviation which you have done. That also you
Yes,
have to comply.
deviation done towards the land of DT, Lordship, which their understanding.
That is one. Second
Yes.
is that parking you have used up for other things.
Yes, Lordship. For that purpose, Lordship, for that only I am placing this paragraph, Lordship. We have leased out the property permanently from the DT, Lordship, with due permission from the Endowment Commissioner, and paying 50,000 per month to supply the. Yes, Lordship. That is the matter on record, Lordship.
Which that
And on the single judge also, that and also in paragraph 5 of the single judge, honorable single judge order, Lordship, the honorable single judge has held that in the parking available as per the British land, Lordship concern, the commercial will continue. If it's no parking, no commercial purpose without interest for the commercial company. That obligation is already there in the record. So far, the survey reason is concerned that under the scheme, there is two things. One is no hindrance to the public. There is no hindrance to the public in this case, Lordship. And so far, the fire safety is concerned. We have applied for the same 80% work has already been done. Only due to seal out the building, Lordship, the 20% is unemployed. But I pray, Lordship, Lordship may allow the this in the building and the time limit to be fixed. I will provide all fire safety, Lordship, as required under the scheme, Lordship.
But regarding the parking lot, the conversion of the parking lot, they are not agreeing. They will vacate this part. Parking lot should be restored to its original.
In judgment passed by the Practice Code reported in 2005 one Lordship, the French colony judgment. Unauthorized construction can be regulated on that
permits. So
yes, so scheme, Lordship,
And the construction should be bona fide. But unauthorized construction, maybe for some misunderstanding, it's
saying you don't want to demolish it. So what will happen to the building if it just stands like that?
But we will regularize it.
Exactly, that is what they are saying.
Yes, we will regularize subject to condition Miller. They meet the specifications for Sabakana.
So what are the specifications you say? Generally, if you say what can be
the specification should kind of page 33.
Given
I placed that Miller. That is also solution between the authority Miller. They have to maintain the flow of the issue.
and the ground floor should be kept open for parking. They are utilizing the ground for some other purpose.
He is still insisting that they will keep it the parking because the land they have under lease, deity's land, they are using that as a parking lot. Is it the case ultimately?
Yes, yes, with permission that has been done by the appeal authority.
2.5 feet and 60.
That is yes, that is under an agreement.
With permission of the endowment.
Maintains the ratio, because if they take 3 plus 1 floor, then parking area they need more. So what is that area they have taken for parking? Is that enough as per that ratio?
But ratio, so far as building is concerned.
No, regarding parking, that is the ratio.
So when parking, the ground floor is used for parking.
I have understood. Now that the ground floor is also being used, that means the parking area will be more required, because floor area and parking area that has some. 10 foot to 3 feet.
No, that is not. But so far as the parking area is concerned.
Yes.
That they have taken under an agreement.
Understood. We are discussing that since all this time we have discussed.
Yes. Well, that agreement is for a temporary period.
So up till that, then it will be locked. It will be shut down.
But you will also can consider this regulation and approval of the building plan.
Affidavit, file an affidavit better.
Tomorrow, to what extent you can relax?
Malad.
I'm not telling you, because if the Sharbuk come up, this the scheme, to what extent you can relax, and I don't know how can you regularize this parking area that you are showing now, taking from the deity's land. It is a street. It is a 2.5 feet and 12 feet street. I don't know how it can be used as a parking space. There in between, I definitely that the areas you are supposed to keep vacant, you have occupied that, and a continuous parking places you have created.
That is
not permissible.
No matters. But this page 30 lordship.
Chronological date and events, he has given the exact measurement. That's it.
500 square feet lordship. Page 30 lordship can have a glance. The trustee of the Endowment Commission Orissa Bhubaneswar is the order dated
500 square meters. 500 square meters.
Yes, lordship.
How much is that? How much is 500 square meters?
1500 square feet.
ଏ ଦେଖନ୍ତୁ ଏତିକି ହବ 10ଟା ଗାଡି ରହିବ 500 square meters. କେତେ ହବ? କେତେ ହବ ଏଇ ରୁମ୍? ବେଶୀ ହବ?
ଆଜ୍ଞା ବହୁତ ବଡ 500
physically verified lordship.
I don't know. No papers in this regard is there.
To a big place. 500 square meters.
B plus 3-story building over the permitted area of 82.32 square meter. And the building area is only 82.32 square meter. And you are saying the 500 square meter is a parking lot?
Yes, sir. That
is exceeded to that. No, that's all right. Yes. But the approved plan, we are concerned with that.
This is the that lordship monthly rent is lordship 50,000 dollars.
Their land was 159.6 square meters. But they have constructed the building of 166.73 square meters. Also. Although they are allowed for construction over 88.32 square meters.
That is where 3 square meter was there. You just come with a 2-page affidavit. Yes. How, as per the scheme, you can realize. That you will see, because this trend should not be encouraged.
Well, if tomorrow, if any untoward incident occurs, then the authority will respond. Yes.
Affidavit will give by tomorrow?
No, it requires some more time. 10 days time will not.
No, 10 days time cannot be granted.
By Friday.
One week time will also be granted. The authorities, the Barampur, I have to.
by Monday.
As your lordship.
After hearing substantially the counsel for the parties, we need clarification from the appellant, the Baharampur Development Authority. As regards how the relaxation can be granted under the scheme for regularization of unauthorized construction 2019. Subject to installation of the safe and fire safety, subject to installation of fire safety points along with the fire engines and firefighting personnel. Stop. There is another issue in respect of the parking. As in the original plan, the basement was earmarked for the parking. But the basement has been now used for different purposes. That apart from the original plan of B+3 building, the respondent the
B+4 they have constructed. Permission was with B+3, they have constructed
B+4. Number 2 and 3 have made the construction to B+4 in complete disregard to the approved plan. So, both the points should be clarified in a short affidavit. That the matter be listed on 4th September 2023. Mr. B.S. Panigrahi, when counsel is appeared with the appellant, and Mr. S.K. Boral and counsel has appeared for the opposite parties, respondents number 2 and 3. Okay. Let us see, but you have a very bad case, I'm telling you.
Floor area and parking, I think there's a ratio, so that you give the, well, now that floor area has increased.
Yes,
2 floors they are using.
So,
accordingly you give the calculation.
65.
Your Lordship, on the last occasion, both my learned friends have completed their argument. And Your Lordship, I have already on the last occasion, I have submitted 118 notes of submission in the first case. And also in the second matter, Your Lordship, one additional submission, Your Lordship, I'm having an additional submission, Your Lordship, in the second case. Your Lordship, on the same issue. Now, Your Lordship has already gone into the entry 72, Your Lordship has already gone into, Your Lordship. I don't want to waste Your Lordship's valuable time. Now, Your Lordship, on that entry, 3 ingredients have to be fulfilled to avail the exemption under that entry, Your Lordship. That is the number 1. The supply has to be supply of service provided to the central government, state government, or Union Territory of India administration. Second is the such service under the training program, Your Lordship. And the third is the total expenditure of such services borne by the central government, state government, or Union Territory. So there is the first question, first ingredient, and third ingredient, Your Lordship. I've already argued much more, Your Lordship, so far as that everything has been done by OKCL, and OKCL can be proved earlier, and that is not a government, Your Lordship. Your Lordship, I have already tried to convince Your Lordship on that point. Now, Your Lordship, so far as the second ingredient, Your Lordship, I'm shortcut because of time. So far as the second ingredient, Your Lordship, may kindly turn to page 5 of my submission. Your Lordship, I have given the pertinent, Your Lordship. It is only submitted that to page 5 paragraph 6, the second question, it is the second ingredient, Your Lordship. That is boot model. Your Lordship don't said that it is boot model.
That there is no controversy.
That's it. And what happened if it is a boot model as per the provision? As per clause 1C, Your Lordship, if this book, Your Lordship, is only for a movement at the page 201.3, 213. The Lordship transfer there 1C, any transfer of title of goods under an agreement will stipulate that property in goods shall pass at a future date upon payment of full consideration as agreed in the supply of goods. My first submission is that it is a supply of goods because it is a boot contract, and also in the contract itself says that it will be transferred at a later date. So it is a supply of goods. Now, Your Lordship, more so, Your Lordship, the appellate authority, there are different supplies, Your Lordship. And pursuant to different supply, in addition to the above, the petitioner for the appellate authority for advance ruling contended that he could not specifically clarify the value of goods supply. In answer to Your Lordship, also I have given the paragraph, Your Lordship. I may not go to all the details from the petition. I have the page number. I have given everywhere the page number. Number 1, installation commissioning service, repair and maintenance service, computer education service. In this regard, to get more clarity regarding the supply, when the appellant was asked to quantify in order to justify the principal supply, Your Lordship, of the value of service, the appellant failed to give any evidence or information. Your Lordship, reference is so and so paragraph. Now, in other also, from the bearing of the contract, it can be ascertained that primary and principal scope of the contract was in relation to the transfer of goods only. The better appreciation of the Honorable Court, the relevant portion of the contract agreement is quoted here. Your Lordship, Section 3, description and scope of contract, page 163. The nomenclature of the scope of contract are as under. Your Lordship, these are the different words, the scope of contract. Your Lordship, I have quoted some of the words. Now, Your Lordship, at page 7, what is the training program? What the training is giving? The bidder will train at least 5 teachers per school for each government and government within the zone on usage of hardware for minimum. The bidders are provided separate manuals covering detailed steps, and Your Lordship, the next manpower requirement. To implement the project, the manpower will be provided by the bidders to complement the team service. Except school coordinator, only one coordinator, that is in the first case 10,000, in the second case that is 7,000, all per month towards deployment of school coordinator by the petitioner. In view of the scope of the contract, it is clear that there is no scope for rendering service as claimed by the petitioner. Rather, the contract provides for only transfer of goods as per the claimant. In order to from the payment term as provided in the contract at page 177 of the petition, wherein under clause 5 it provides for payment for hardware, software, and connected accessories, and payment for recurring expenditure, Your Lordship. On the payment form also nowhere it is mentioned that for the earliest training program or computer education service, the petitioner will be paid by the employer. It's Your Lordship, for goods, against the goods for payment. It is also provided as the contract agreement or transfer of goods as mentioned under the scope of contract. The petitioner will get its entitlement from employer. It is important to state here that neither the contract nor the payment term provides for the earliest computer training program. Your Lordship, computer training program for a computer education service as claimed by the petitioner. Under clause 3 also, the contract in hand provides for final accepted price so and so per school, average one contract price so and so. And these are the reference. Now, Your Lordship, during the course of argument, the petitioner contended that as per clause 4 of the contract agreement under section B, section 5, page 180 of the petition, it provided that for computer education course, it is respectively submitted that say clause in respect of manpower requirement, the scope of contract clause A of section 3 of the contract act. Your Lordship, and after the said clause, the manpower service to be provided by the petitioner at free of cost, except for school coordinator And for the school coordinator, the petitioner is entitled to get its remuneration of 10,000. Your Lordship, from all these arguments, from all these points, Your Lordship, Section 8, as per Section 8, Your Lordship, again, Your Lordship has gone into Section 8, and from Section 8, it is clear that there is a principal supply, Your Lordship. What is that principal supply? As per Section 2, subsection 90, Your Lordship, for a moment, Your Lordship may kindly turn to Section 2, subsection 90, that is the definition of principal supply. Principal supply means the supply of goods or services which constitute the predominant element of a composite supply, and to which any other supply forming part of a composite supply is ancillary. Your Lordship, and so far as the Section 8 and as per Section 2, subsection 90, Your Lordship, here the principal supply is the supply of goods, and so far as the training program is the minor supply, Your Lordship, and also for that supply, Dr.
So that's all.
Your Lordship, because Your Lordship must understand, Your Lordship, I have already tried.
You have argued that whatever the training is concerned, it doesn't carry any value.
No, Your Lordship.
And only the 5 teachers' salary going here.
Your Lordship. So, Section clearly applies.
So this is so minimal, it cannot take place of the principal supply.
Your Lordship.
And according to you, since the transfer takes place after this project is over, there is a clear the transfer of goods.
Transfer of goods. So there is no question of from Your Lordship. And then one more thing, Your Lordship. And one more thing. Yesterday I had submitted my judgment. And the judgment is submitted an exemption notification of 2019. Today has Your Lordship, that paragraph 19. Many judgments have been taken into consideration by Honorable Supreme Court. Your Lordship, just to read the 3 lines, Your Lordship, we have noticed above, Your Lordship, paragraph 19.
Yes. Power purchase agreement.
About power purchase agreement allocating the energy to the Gujarat so and so, power supply was to given so and so. Your Lordship, it is well settled, but taxing statute are to be strictly construed specifically the exemption notification. Here it is exemption notification. It has been held that statutory provisions providing for exemption has to be interpreted in the line of words employed in it that cannot be the addition or subtraction from the statutory provision. So the court in so and so judgment, Your Lordship, all the judgments, many judgments have been cited here, and many submissions and everything have been carried out, Your Lordship. So this judgment is a vital judgment and latest judgment, Your Lordship.
But it doesn't lay down any new principle.
No, Your Lordship, this is from English court sheet, Your Lordship, and also I have narrated in my submission. Even from that day, this principle is going on.
It is 6 years old, you say it's latest.
In Cape Brandy Syndicate, Your Lordship, from Cape Brandy Syndicate, the publication is going on, and I have cited at paragraph 8 of my submission that Cape Brandy.
All right, thank you.
And so that on this issue, I have submitted one additional written note in the second case, because I am obliged, Your Lordship, even though I have argued shortcutly on this ground, but at the time of preparing the judgment, Your Lordship has pointed out this point, Your Lordship, I am obliged, grateful, Your Lordship.
Mr. Singh and Mr. Chilana.
My lords.
Would you like to respond that today there is no time?
We would
like to respond.
Yes, we would like to respond.
I think your submission covered in the matter what you submitted earlier.
There's one aspect in this as to what the advanced ruling authority has gone into, as opposed to what my friend is arguing. We just want to point out that aspect. My lords, may give us a short date. We'd make those submissions on that date, my lords.
5th of September. This will be the final date.
My lords are giving 5th of September.
Tuesday.
Post lunch, my lords?
Definitely post lunch.
8 p.m.
How much time would take?
I will take, my lords, not more than 10 minutes by the clock.
Mas I only need 2 minutes, my lords, to highlight my alternative petition.
No, I understand. Yes. So we fixed on 5th of September, 3 p.m.
Grateful, my lords.
Grateful, my lords.
Oh, fixing on 3 p.m. So, part Mr. Sunil Mishra, Learned Standing Counsel, City and VST, appearing for the opposite parties number 2 and 4. So, Mr. Mishra on the point, so taken up for further clarification, has made his submission and also to supplement and summarize the submission. He has filed additional written note of submission along with a copy of the judgment in Asia Steel India Limited and others versus State of Gujarat and others, colon 2017 8 SSC 354 stuff. In both the case, just this way. In one case, the first case he is appearing for 2, 3, and 4, and in the second case he is appearing for 2 and 4. Okay.
Written note is by not by you.
You see the
Written note.
I have some given.
Somebody else has signed.
Your Lordship, my additional sign.
So you are standing counsel or senior standing counsel?
Standing counsel.
Okay.
Manoj, the center is not going to make any submissions. It's only the.
You have filed one note also.
I have filed. My question, Manoj, is the CGST department not going to make any submissions, or they are adopting what the Odisha?
No, I don't know. Mr. Chimanka is here.
Yes, I'm supporting. I'm supporting
Mr. Mishra, sir.
Mr. Mishra has taken so much of pain, so I don't want to add anything to Mr. Sam.
All right.
So our name can be mentioned.
Your name is there.
Chaudhary Mishra and Mr. Chimanka, both can be mentioned.
Just find out. Definitely their name is there. No? Your name is there.
This is if it will necessary, then I will reply because I am not satisfied with my argument today because I have argued. So if required at all, let's.
All right.
Gratefully.
Today? Yes.
If I got stand permission, one matter item 38 minutes. The challenging quarantine 38 minutes. The challenging quarantine procedure minutes plus respect of limestone minutes, which is for industrial use minutes, import through Dhambra port minutes. Plus you actually protected minutes. That's what I'm only submitting. If I also can take a certain date, either first week or second week of September minutes.
So September to be excused because it is to go into now October because the board is very congested.
I understand minutes. I will suggest for 11, subject to my last convenience. I try my
A lot of matters are there. Already 71 matters. This problem are being created now.
We'll take my
Or
chance.
we'll try on 21st of September.
21st.
Let's see.
Item
Your matter will take up day after tomorrow.
Yes.
I will give the date.
Item 27. Item 27 at 2 p.m. minutes.
Day after tomorrow, 2 p.m. There is matters in there, no?
Item, pardon.
You come at 2 p.m. Let us
Yes,
see.
item 27 minutes. Like the matter, date of it matter. That is, I am attending the termination matter, so that's why it come and mentioning. But today did not reach. So day after tomorrow or next week matter for my lord's
Date in the month of September. Okay.
Item 53, my lord. This is an election dispute matter, my lord. The matter, this election petition has been stayed at my list, my petition also. My lord, may be taken up tomorrow if possible because in the light of Asian resurfacing case, this interim order, the learned tribunal is now not complying. He's saying that it will be lapsed. Yes. It can be taken, it is ready otherwise. It can be taken up tomorrow at least.
Already you come at this 12 tomorrow.
Item 23, my lord.
23, I am for responding on the last occasion question of the council take time which needed to the reply filed by the opposite party. So you please short date.
Or given a short date, it will be given.
Item 51, item 15, criminal appeal bail application didn't reach today. I pray short date
tomorrow.
Item 31.
Yes.
Raise read appeal by the state. Content petition is there. You will take it out tomorrow.
Always. The content is to me, right?
Pardon to make a motion, my lord. Not those appeals.
There is a break bench. I am to rise now. Yes.
Brought by special notice, my lord, may be kindly taken up tomorrow.
Mr. Mishra, are you ready for these matters?
Yes.
Tomorrow we take up. Tomorrow.
Item 49, item 49.
Tomorrow. Let us know tomorrow. Tomorrow afternoon, but I mean after the post-lunch session. Because pre-lunch session is not possible. Post-lunch session, you come, just try to accommodate. I don't know.
My lords, item 32, if my lords could have it tomorrow, this is pertaining to the Orissa State Cooperative Bank, the appointment of the managing director. I won't take more than 5 minutes, my lords. I just have to show.
Come post-lunch session.
Tomorrow? Most obliged.
Tomorrow.
For order cycle over.
So we have filed this IA 5242 of 2023, my lord. For recall of order dated 11/5/2023, my lord.
IA number
5242 of 2023.
Where is the time?
X.
Maybe
This was done because of the postal report, my lord.
It is flags.
No, he has not. There is postal report. You also see that on the list, you also can find it, but on the postal report.
Okay.
The case was dismissed since there's a
later. I'll also see that report of the post. Resist. That similar list, not today's list. That is the noting in the record also.
Expire and left with what?
I don't understand why.
Let us check also.
He is saying that he is a leave.
That is the thing.
So, that order we have made submission on the basis of that postal report. On the basis of that submission, that has been
verified the person.
Yes, my lord, just file this by way of affidavit.
No. I am asking you whether he is the person or someone is from his family.
May I submit, my lord? You'll also may direct him to appear in person. You'll also may fix a date.
When he can come.
Next week, if lost.
Oh, they have retired as expired. Postal report says he's retired.
There is no need. 13%, well, you can recall that order. 13% 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%, 13%,
Just a minute. Unthinkable thing happens sometimes.
Also, this rate petition was filed when he was in service.
Just a minute. Then we will let you. In the registry's note dated 16/2/2023, it has been stated that notice on admission issued to the sole respondent by RP with AD. Notice was issued. Such undelivered notice returned as returned with report, quote unquote, expire and left, unquote. Thereafter, it has been stated steps to bring the legal representative be taken. But on re-verification of the postal report, we find that the registry has wrongly read the said report by causing serious deviation in the procedure. The report states, postal report states as follows, quote, addressee retired and left this location, comma, hence return to the sender, unquote. Therefore, the previous order relating to the substitution is recalled. That apart, what is your good name, sir?
S.S. Mahapatra.
Mr. S.S. Mahapatra, Learned Counsel, who has appeared for the said sole respondent to press the application for recalling the order dated 11/5/2023, passed in WN number 682/2022, whereby the writ appeal was dismissed for non-prosecution. So, Mr. M.K. Kuntialan, Additional Government Advocate, appears for the respondents.
No, well, appellants, madam.
You are for the appellants.
Well,
appears for the appellants, sorry. Appears for the appellants. So, would you oppose the prayer of?
he has filed that, so I am not opposing.
I have filed this recall petition, IA.
No, I have not understand. The appeal can be dismissed for the absence of respondent.
No, madam, that you must be looking at the order dated 11/5/2023. You also may see that order, madam. That was not dismissed for default.
That's what this is. Not dismissed for default.
For not taking steps for substitution. The appeal was dismissed.
Disposed for not taking the steps for substitution. What is that order?
11/5/2023, madam.
Why you have filed this? Well, your appeal has been actually scored up. Why have you filed this?
Well, because if since this appeal was preferred, I was granted order was passed by the learned single judge.
Have you read the order correctly?
Because if this appeal does not succeed, I will not get the retrial benefit.
You are not the appellant.
The respondent, my lord.
That is why. How you can be affected by the order? You have not challenged that order. How can we can give you the relief? Their appeal has been dismissed, stating that this will not create any precedent. That is the order.
Instead of filing that application, when it came to our mystery, we should have filed that application.
For recalling this order.
Yes, my lord. But since he has filed, so I am not objecting.
Because, my lord, I will be debarred from getting my retrial benefits.
How?
Because my lord, the learned single judge allowed my.
You have not challenged the learned single judge's order.
It was allowed, my lord.
Then what you debarred? You enjoy the fruit of this. Why have you filed this application? I don't understand why. How you are affected by that order?
Because, my lord, in the series of writ appeals, my lord, the government preferred, the matter was remitted back to the coastal bench, my lord. Although if I apply for the retrial benefits, the department will take plea that since in a large number of cases, the Honorable High Court has...
Because in your case, that what is the question of law arising from this impugned judgment open decision in some other appropriate case. He is apprehending that in those cases will be taken, his benefit will be affected. He wants also that these matters should be remitted back.
Yes, my lord.
This, you can do that.
Yes, for that reason, I am not objecting. In the beginning, I am saying I am not objecting. His petition. But he should have taken the benefit.
We are discussing that he should have taken the benefit of the order.
No. From the very beginning. It was issued on the second set, such notices has returned. Quote unquote expired and left, unquote.
Test for bring clear retrial be taken on the report to find that registration of the government where
the postal report, wrongly read the postal report.
And what is clear from the procedure. The postal report says that the addressing the return and left this one. Hence return to the
sender. Return to the sender.
Therefore, the previous
previous orders relating to the substitutions are recalled. And then
that application appear for the sole respondent to the application for recovery order dated 11/5/2023. Parking W number 682 of 2023. Therefore, the capital exposure unproceed.
The said application is allowed unopposed. So accordingly, the order dated 11/5/2023 is recalled and WA number 682 of 2022 is restored to its original file. Now we set aside the order of the learned single judge and write down. So in view of the order passed today in IA number 522 of 2023. So earlier order is 522, huh? And 22 such and such. 542, okay. This appeal is taken up for consideration on merit as agreed with the council for the parties. By which can you refer to the order by which the similar matters was remitted back?
In fact, what has happened, some similar matters were
remanded to Honorable Singh because no count was filed. Subsequently, in those cases where notice has been issued, your Lordship has already decided the issue. What has happened in this case, that during pendency of criminal case and departmental proceeding, the Honorable Single Judge had directed to give them promotion. That was the subject matter of challenge. Though in those cases, the councils have appeared. In those cases, the matter have been disposed upon merit, that your Lordship has allowed a writ appeal saying that they cannot get promotion during pendency of either criminal case or departmental proceeding.
Yes.
That is a batch of cases has been decided where the councils have appeared. But where councils have not appeared, those cases were remanded to Honorable Single Judge that prior to that matter have been remanded to the Honorable Single Judge for disposal. If your Lordship, I can give that judgment, if your Lordship can say that it is a covered judgment, giving that number.
Do you have a copy?
No, my lord. It was with regard to the party's name Joseph Barik.
And that is the appeal number 805 of 2021 and batch of cases. Sir, my lord, the party to that judgment. And I can share that copy with my lord friend also.
Joseph Barik. Huh? Joseph Barik.
State of Joseph Barik.
Joseph Barik.
He knows that judgment. This is covered by this judgment.
So you take up tomorrow.
Yes, my lord, I will give that copy also that your lordship can take up tomorrow, my lord. And I will supply him. I will that copy or I will supply.
Tomorrow. In this appeal tomorrow for disposal on merit. It has been stated the bar that this appeal might be covered by decision of this court, but because the learned counsel for this parties to produce a copy of that judgment before us. All right.
Well,
just name the counsel. As the